Is inclusion just hand over the slip, do not mention.
My lord, may I pray one thing, my lord? My lord, two separate appeals arising from the same judgment. When section 5 was disposed of by Lord Justice Barchi, he said both the appeals taken up. So, my lord, I mentioned both the appeals, my lord, arising from the same.
Billing connection. Inclusion. Lordship, billing connection with application. But
Lordship,
inclusion
I pray for your Lordship's kind indulgence, my lord. With regard to item number 52, my lord, I will be in today's list. I'll be praying for a precedence, my lord, because I had come to learn, my lord, that the hospital authorities are going to issue the work order. And this appeal has been filed, my lord, against the order passed by the learned single bench directing cancellation of my bid, my work.
Very well. Sorry, madam.
Lordship, there is extreme urgency, my lord. Lordship will
Sorry,
find
next.
any time, my lord.
Release from our list. Release. We'll release it. Go.
Lordship, no, Lordship.
Then please do not waste our time.
was seeking leave to file an appeal with the Xerox copy of the trial court order, my lord.
Why?
My lord, actually, the petitioner is the de facto complainant. The appellant filed the convicted persons filed the appeal, and entire lower court record arrived before the High Court, my lord. That is. Grateful, my lord.
Now,
The state.
appearing for the acquitted respondent, my lord. In this matter, my lord, what happened, my lord?
That matter, section 5.
No question of happening today. It has been listed for filing affidavit.
My lord.
Yes.
File.
My lord, I'm praying for more time, my lord. Because, my lord, you kindly see, my lord, I have taken out the preliminary objection regarding the maintainability of the appeal before this honorable court, my lord. On the ground, my lord, that the order was passed by learned assistant session judge. Against, my lord, assistant session judge, my lord, appeal ordinarily lies before the learned session judge. Allow him to speak. Yes. The state has not filed any appeal. He is doubting.
Several occasions.
Whether you will allow or not. Please. My lord, I had taken a preliminary objection regarding the maintainability of the petition of appeal before this court, my lord, because my lord,
File this appeal.
appeal filed by the appellant.
Appellant. That means
The de facto complainant.
Appeal against
you are the convict.
I'm not the convict, my lord. We are the acquitted respondent. I had taken out a point, my lord, that this appeal is maintainable before the learned sessions judge, not before this honorable court.
We shall give you opportunity.
And that point, my lord, has been decided against me. My client, my lord, approached the High Court Legal Aid Services for assailing the order before the Honorable the Supreme Court for testing the veracity of the order. But the High Court Legal Aid Services, my lord, declined to give any assistance to them. Now they are, my lord, writing letters to NALSA for, my lord, legal assistance so that this order may be tested. Because whether an order passed by assistant session judge can be appealable before the High Court directly.
So we shall hear the point of maintainability. No
No,
problem.
my lord, that has been decided.
Decided.
That has been decided. For that, my lord, my client, my lord, wanted to approach the Honorable the Supreme Court. The High Court Legal Aid Services, my lord, refused that prayer. Now they are approaching, my lord, the NALSA so that they can move the Honorable the Supreme Court for, my lord, testing the order whether under 374(3), the appeal is maintainable before this court, but this court, my lord, refused my prayer and directed me to, my lord, file affidavit.
Sir, when the two judges discuss,
Ma-
you should stop submitting.
Well, I'm not seeing, my lord. I'm
Basics.
very sorry, my lord.
Look, sir, if you want some time, we'll give you some time. This can't wait indefinitely.
But certainly-
When you will go to Supreme Court,
My lord, I'm praying for at least 4 weeks time, my lord.
No. What? This direction was given on the 26th of August for filing affidavit. Is this a joke?
No, my lord. No, my lord.
1 week, file it. Or else we'll condone the delay. On the prayer made on behalf of the respondent, respondent oblique accused,
My lord, may
2
weeks, my lord.
time to file affidavit in opposition is extended by a week from date. Stop. Paragraph. A prayer was made for 4 weeks' time. Stop. That, in our view, is unreasonable. Stop. Direction for affidavits was given on August 26, 2025. Stop. By now, the affidavit, by now, affidavit in opposition in connection with the condonation application should have been filed. Stop. However, taking a lenient view, we have granted 1 week's time to the respondent oblique accused to file his
They are,
male.
they are, my lord.
Accused is male.
No, my lord. They are.
File there. Respondents their affidavit in opposition by within a week. Stop. Reply thereto, if any be filed within a week thereafter.
3 or 4 days.
What? 3 or 4 days? Within a week. Within a week thereafter. Paragraph lists the matter under the appropriate heading 2 weeks hence.
Dragging the matter.
Deep look.
Item 2,
Passover, cholo.
3, 4, 5, 6, 7, 8, 9, 10,
Madam, for the petitioner, appellate.
10. Conviction.
Well, there is 3-day delay in filing
Sir?
appeal. Madam, serving statement. But I will, sir. Let there be done.
There is a delay of 3 days in presenting the appeal against an order of conviction. Stop. Let service of the condonation application be, along with other papers, be effected on the office of the learned public prosecutor, and affidavit of service be filed in court on the next date. When will I keep? When will
2 days after.
2 days.
2 days after.
Paragraph lists the matter on Thursday.
Deeply obliged.
Thursday,
sir.
Thursday.
Deeply obliged.
Under the same heading. This is Mr. Gupta. Conviction under which section?
307.
item 11, 12, madam. My lord, this is
Mr. Bitter, we'll take it up. We'll run through the list once. I will first call করে দাও
14, 15, 14 minute I have put
Yes. We'll run through, we'll come back.
15 for the petitioner.
Here,
15 for the petitioner.
we'll take it up in the second call.
16.
16 Lordship, I am on behalf of the appellant, Lordship, led by Mr. Partho Sahodhi Bhattacharya. He is on his leg. Lordship.
Second, pass over.
I am appearing for this thing.
17. 16 with 17.
17, my lord, I am
17,
for
my
one
lord,
of the appellant. My lord, Mr. Miller Mukherjee is for the other appellants.
in respect of 17, my lord. Item number 17, Mr. Miller Mukherjee appearing in this matter.
What
This
do
is
you
against
want?
Court number 34, my lord. 28, my lord. Pass.
You asked, what do you want?
Pass over, my lord.
Chalo.
18.
Well, 18 I am for the appeal.
19. 20. 21. 22.
22 I am for the appeal.
23 and 24. 25.
25, my lord, I am for the appellant.
26 with 27 and 28.
No. Pass over.
আমি দাঁড়িয়ে আছি 29 with 30. 31. 32 to 36. 37.
37, my lord, I appear for the appellant petition.
38 to 41.
41, Your Lordship, I'm praying for a short pause over. Mr. Imtiaz, I'm disappearing this matter.
42. 43. 44. 45. 46. 47. 48. 49. 50. 51. 52.
Lordship, I appear for the appellant one.
53. 54. 55. 56. 57. 58. 59. 60 and 61. 62. 63.
63, Lordship, I am for the appellant.
64. 65. 66. 67. 68. 69. 70. 71 to 73. 74. 75. 76. Second call.
Abhijit,
Item 2.
for usual, this is an old appeal. Huh? बोलते हुए those steps taken.
3. 4.
Nothing.
5. 6.
Not right application. Actually.
7.
My lord, I am appearing for the state respondent led by Mr.
Give
Chattopadhyay.
your appeal.
8.
Submission of appeal करनी. क्यों ना करें? नहीं जो
না admission dismiss
এন এ মানেটা কি? যে নিচে লেখা আছে এন এ, এর মানেটা এই তো, কিন্তু এই তো ফাইল আছে বলছে।
অ্যাডভোকেট অন রেকর্ডের ব্যাপারটা হ্যাঁ এটা অ্যাডভোকেট অন রেকর্ডের নাম আছে না, আগেরটা তো না না এই যে নোট করে না না জিজ্ঞেস
হ্যাঁ, তোকে বুঝতে হবে তো, আগের দিনও বলেছিলাম, জিজ্ঞেস করো ডিপার্টমেন্টকে তোমরা। হ্যাঁ, নট টু রেকর্ড, নট টু রেকর্ড।
9
Same, not today.
10,000 item 11
Lordship, in this matter, Lordship, I am appearing on behalf of the petitioner.
Read.
This is the renewal of the bail prayer. I
Sir,
have
one
upped the
second.
state already.
1 second.
Lordship.
Where's your affidavit of service?
Yes, yes.
Is Miss Sinha who's appearing for the state?
Yes, yes. I have served, Lordship.
Means the legal man is appearing so far as the appeal hearing in concern. My lord, so far as the application is concerned, there is some confusion. If I come back on Wednesday, my lord.
That's all.
Wait,
Lordship.
Wednesday. Right. Paper books filed.
The paper book
Is ready. Is ready. Is ready.
Why don't we hear out the
And
appeal?
Trump's imprisonment only 10 years. And he is in jail for about 6 years. Half of the term.
Come back on Wednesday.
Lordship. Obliged.
item 12 week 13.
My lord, this is that matter. My lord, these are the bail applications, the corrected ones.
Oh, I see. এগুলো পাওয়া যাচ্ছে না।
The lady is in custody for 14 years. My lord,
যে প্রথমে একটা অ্যাপ্লিকেশন নেই
হ্যাঁ।
একটা নেই প্রথমটাতেই প্ল্যান 4
initially they had filed one appeal to their lawyers. The lawyers started, my lord, they did not appear.
this means
Best of my knowledge.
The principal accused has been granted bail.
No, both of them, two persons, Ojoy and Mili, both are in custody for more than 14 years. I am representing Mili as directed by the High Court legal aid. And Mr. Ganguly, Shandipan Ganguly, is appearing for Ojoy. Because they had filed an appeal initially. The lawyers did not appear thereafter. Then they filed a jail appeal. In those jail appeals, my lord, Mr. Ganguly and myself, we've been appointed to represent
So
them.
the appeal filed by the lawyers,
Original appeal was dismissed by
that was a composite appeal.
composite appeal. This one is the composite appeal which remains, and separate appeals filed by
Have been disposed of.
was disposed of by Justice.
Today, is there a bail application on behalf of Ojoy?
Yes, madam.
Yes,
Yes,
Ojoy, he,
Item number 13, madam.
I see.
and in 12, this is the bail application of
Right.
Mili.
So it was a custody trial.
Ojoy is not there.
এটা আমি আছি তো,
হ্যাঁ।
আমি আমারটা
It was a custody trial.
custody trial. And 14 years, now my lord, have elapsed.
Has the offense committed?
302.
302. So have you gone through the record?
Yes, my lord. They have completed even in the last order passed by this honorable court when the suspension of sentence application was heard out, it was recorded, it's more than 10 years. My lord, that was in 2022 January. So in 2026 January, it makes it more than 14 years. My lord, if your lordship sees Annexure A, page 13.
Order dated 3rd January 2022, the second paragraph. What? And they are in custody from June 2011.
What is the 3rd January 22? There is no eyewitness in this.
There's no eyewitness. Vital witnesses are PW 4, 8, and 10.
So what are the causes? Why this bill was not taken up?
It was not taken.
Hearing? Why?
It was not heard, my lord. That's all.
Paper books are ready.
Ready.
Everything is ready. We are ready to hear the appeal.
When will you argue the appeal?
14 years, the lady in 14 years.
That is different. We are ready to hear the appeal. Are you ready?
As of now, today is, my lord, I believe the bail was filed for this purpose. Your lordship,
Sudan Singh.
Sudan Singh, Kashmira Singh, Nistina, what do you say?
my lord, is
5 years have passed.
10 years.
5 years from conviction.
14 years now, I am in fact entitled to remission hereafter.
Very stringent conditions. It's because we couldn't hear the appeal. These two applications, these two applications for suspension of sentence and grant of bail have been taken out by the appellants in an appeal preferred against a judgment and order dated September 16, 2020, passed by the learned additional sessions judge, second court, Sialda, South 24 Parganas, in sessions trial number 1 bracketed 12 bracket closed 2012, sessions case number 1 bracketed 10 bracket closed 2011, thereby holding, convicting the appellants for offense punishable under sections 302/34 of the IPC. Stop. The appellants were sentenced to suffer life imprisonment and also were directed to pay fine of ₹2,000 each. Stop. The paragraph. Present appeal was filed in the year 2020. Stop. In 2022, the who is the first appellant in the appeal? The husband.
First appellant.
Well, there are two different appeals, Millet.
Single appeals each.
Single appeals each.
Filed then, single appeals filed down.
Oh, two appeals here also.
Millet, CRA 16 of 2021 is by Millet Ojoy Shen.
And CRA 247.
It's not. In the year 2022, the appellant in CRA 211 of 2021, being Nili Pal, had approached a coordinate bench for suspension of sentence by filing CRAN 2 of 2021. Stop. That application was dismissed by a coordinate bench. Stop. Hearing of the appeal was expedited by directing filing of paper books after receipt of trial court records. Stop. Paragraph. The appellants renew. At that time, only Mili had approached for suspension of sentence.
No, Millet. In that,
Only Mili.
Millet kindly sees this particular order.
Do not confuse us.
Millet.
Just tell us.
Millet, in 211, Ojoy Shen had not filed any appeal for application for suspension.
Mili now renews her prayer for suspension of sentence. Stop. The other appellant, i.e. Ojoy Pal, has also made an application. Ojoy Sen has also made an application for suspension of sentence. Stop. Paragraph. The applicants say that they are in custody for a period of 2 months short of 14 years.
14 years, 6 months.
Oh, over 14 years now.
June 2011.
For 14 years, 6 months. Stop. Even after the order of conviction was passed, they are in custody for close to 6 years. By close to 6 years.
Little short of 6
Close to 6 years.
Close to 6.
Stop. Paper books have been filed, but the appeals would not be heard. Stop. Relying on the ratio of the decisions in Kashmira Singh and Sudan Singh, give the full causality and the reference, citation. The applicants pray for suspension of sentence and grant of bail pending disposal of the appeals. Sudan Singh Sudan Singh. Pending disposal of the appeal. On any terms and conditions, on such terms and conditions as this court may deem fit and proper. Paragraph. Learned advocate for the state says that the prayer of the applicants, prayer of one of the applicants, i.e. Mili, was rejected by a coordinate bench on the grounds recorded in the order dated January 3, 2022. Stop. Prima facie, there are sufficient material and evidence on record to support the order of conviction. Stop. Therefore, comma, bail should not be granted to the applicants. Paragraph. We see that the applicants are in custody for a very long period of time. Stop. They were in custody throughout the trial. Stop. Even after their conviction, comma, they are in custody for almost 6 years. Stop. The appeals filed by the applicants are of 2020. Stop. We cannot say with any certainty when the appeals may be heard. Stop. There are prior appeals to be heard also. Stop. Paragraph. Hence, comma, without making any comment on the merits of the case and solely on the basis of the ratio in the cases of Kashmira Singh Supra and Saudan Singh Supra, we suspend the sentence of the applicants. Stop. Kure accordingly kure তোমার কি নাম হলো তন্ময়ের কাছে যেটা আছে ওই ফরম্যাটটা
He shall not leave his local residence. What is the police station you did not mention? Hilipal.
No.
What is the local police station? You did not mention. Ultodanga police station?
না দুর্গাচরণ
I do not know.
শোভাবাজার
I do not know. You did not mention.
it will be শোভাবাজার area.
শোভাবাজার
We will not leave the jurisdiction falling under the AC North.
Oh,
AC North.
What is the jurisdiction you tell me? It's not local.
Jora Shako. This is
Probably.
Jora Bagan.
Sure.
Area is Shobhabajar, I can understand from the address.
Why don't you, Mr. Metter, find out and give it to him? He's a good jurist. Vague.
Jora পুলিশ রেখে নেবে আর ওরা মধ্যে স্পাইস থাকে ওর একটা অবস্থা কিন্তু যে চোখের তো আমরা দেখি অনেকে লিখছেন
আমাদের কমিটি
Well, the 14 years, they will not leave the jurisdiction of Kolkata.
Why?
Well, so harsh after 14 years, so harsh. In a case of circumstantial evidence, where I most likely in the end even acquitted. There is a high chance of acquittal. A lady having a child. Not leave Calcutta. She will not leave Calcutta. Well, subject to correction, my lord.
Metropolitan limits. The metropolitan limits of Calcutta. Metropolitan limits of
FC.
And then report to
And report to Ultodanga because the cases of Ultodanga PS will report.
He's a bar dancer.
Huh?
He's a bar dancer.
Was.
So that's why you are saying.
That is no. The Durgacharan, she was a bar dancer and the address Durgacharan Mitra Street falls near Shobhabajar. But Shobhabajar falls under probably Jorabagan or
shall not leave the metropolitan limits of Calcutta, shall report to
the officer in charge of Ultodanga police station.
এটা কিন্তু খালি ছেলে
Because the
এটা খালি ছেলে
Yeah.
এটা
নাম দিয়ে দিলে তো মজা হয় হ্যাঁ ও কি
and only before the court of the CJM Shialda. ACJM Shialda.
what before the court of the CK?
Yes. During the pendency of the appeal, your lordship can direct him to report once.
No, why? They are burdened. We are given condition. We are asking about
residential.
police station jurisdiction. You are not aware. So we are giving that direction. He shall or she shall remain within the jurisdiction, metropolitan limits of Kolkata.
Yes, and Ajoy will report to Shobhabajar police station, Ultodanga police station once every fortnight.
Malad, then you would have to leave the jurisdiction of Kolkata, Malad. Ultadanga is outside the.
Khalid, Twitter will not leave excepting for the purpose of attending, reporting to the police station, indicated herein below. ঠিক আছে? Both the crans are in the list today.
Yes, Malad. There are two separate appeals. The first appeal is Millipal. The second appeal, CRA 16.
Why we are confused, sir? You see, under item number 12, there is no cran listed.
Malad.
Both crans are listed under item number 13.
No, Malad, item number.
Cran was filed today before your lordship.
That is why.
Pursuant to your lordship's direction, that is
now-
why it is not listed. It has to be
Malad,
listed.
Malad,
It has to
if I
be
may only clarify, item number 13, the first CRAN is for suspension of sentence, CRAN 1 of 2024.
Yes.
CRAN 2, Malad, has not been filed by us, Malad. It was filed by the third person who has not appeared before the court, Malad. Several notices were issued to him. So both the CRANs are by Ojoy Sen in item number 13, Malad. CRAN 1 is for suspension of sentence in item number 13, Malad.
ঠিক আছে, তুমি 12 যেটা করবে, এই যেটা আজকে ফাইল নিয়ে চলে গেছে, আজকে এক্ষুনি যেটা দিলেন একটা, এইটা ট্রিটেড অ্যাজ এন রেজ লিস্ট করে গ্র্যান্ড ফোর, ঠিকই আছে, মিলির অ্যাপ্লিকেশন গ্র্যান্ড ফোর, ঠিক আছে, করে সবকটা ক্রাইম ডিসপোজড অফ। লাস্টে লেখো, let the appeal be listed under the appropriate heading. Appeals. Appropriate heading, 3 weeks hence. Three weeks.
Obligement. Next team. Satisfaction of ACJ Shalda.
Item 14.
I am for the petition. The Supreme Court is state Malad led by. I am led by Mr. Tapan Dattu. Here is the affidavit of service.
Ready.
Malad, conviction under section 6 of the POCSO Act for 20 years. And your petitioner is in custody in jail since 20th May 2023.
Take the microphone, sir.
2.5 years. 2.5 years.
Custody trial, no.
No. Kindly come to the last.
He was all along on bail. There is no adverse remarks against him. There is no misuse of liberty. Was just granted to the by unattached. Now, my lord, after my lord, conviction, he is in custody.
When the conviction was?
19th of May 2023.
23. What is the age of the victim?
Victim age.
5 years, my lord.
5
years. 5 years.
5 years. And what is the age of the convict?
Now 70.
Why you are laughing?
70.
Now 70.
70.
Now.
17. What is?
70.
70.
70 and 5.
These are allegations. Can you see what is the allegation?
Then we have to hear the appeal.
Yes,
What is the ground for? What is the ground for praying for bail?
In court bail, you also kindly see the last annexure, page 49. He was seriously, and information was sent to the
49.
14 to the relatives of the accused person, the appellant, and his health is being deteriorated day by day.
This is CRAN 2 or what?
CRAN 2.
What is CRAN 1?
CRAN 1, bail petition.
This is the petition. Earlier, an application was filed with the novel court and that was rejected. Subsequently, under compelling circumstances, this application was filed.
Where is the rejection order?
Page 50, Page 50.
Page 50 of what? CRAN 1.
Page 50 of CRAN 2.
CRAN 2.
Page 47, my lord. Application. And page 48. Page 48 is the order.
2nd January 2025, your bail prayer was rejected.
But subsequent development is his health is deteriorating in the custody.
What is the report?
That testimony can you see the
Not once, more than once his prayer was rejected for such. What are you saying?
No, only one.
Look at the order dated 2nd of January 2025. Justice Bagchi's division bench.
No, my lord, another matters. ওগুলো অন্য matter. অন্য analogous অনেক matter আছে।
Analogous there are number of matters. Can you see the top, my lord? Cran 1, Cran 2, Cran 3. The other matter, not this matter. I have moved only one.
Case the present applicant is Surjo Kumar Mahapatra.
190.
Justice Bagchi's division bench records.
Yes, but the other matter, not this appellate.
Anyway, January 25 rejected. Why should we consider now immediately?
Can you
Last annexure.
see the last annexure?
What has happened to him? What is wrong with his health?
No, his health has been deteriorating.
Heart element.
File a report. File a report regarding his health condition.
That is
File a report. Have you said anything specific about his health condition?
Lordji,
Where?
last annexure.
last annexure. Can you see for a moment? Page 49.
Last page.
Hereafter, my instruction is
49. But the paper book is ready, madam.
Oh, he has been admitted to hospital.
Yes.
File a report, sir. File a report. The applicant was convicted for commission of offence under section 6 of the Oxford Code.
This was filed on. He was admitted on 28/1/2025.
Hereafter, it is
January 2025.
That one, what is the condition that can be produced by the state?
Oh, you must.
Report.
And
Condition.
was
My instruction is
was sentenced to suffer 20 years rigorous imprisonment by a judgment and order dated
Main application.
May 19, 2023, passed by the Learned Court of the Additional Sessions Judge, Second Court, Special Designated POXO, Paschim Mednipur, in POXO case number 46 of 2017. Stop. Paragraph. Learned advocate for the applicant, public appellant, says that the appellant is about 70 years of age. Stop. He was admitted to the Midnapur Medical College and Hospital, Paschim Midnapur, on January 28, 2025. Stop. Thereafter, his condition has been gradually deteriorating. Stop. Presently, he requires urgent medical attention. Stop. On that ground, the applicant renews his prayer for bail, which was last rejected on January 2, 2025 by a coordinate bench in Scran 1 of 2023. Paragraph. Let the state file a report through the superintendent of the concerned correctional home as regards the present health status of the applicant. Paragraph. Mr. Vishwash, how long you will take? Paschim Mednipur? 1 week? 10 days? 1
10
week?
days, 10 days.
Paragraph. List the matter once again. 10 din baade date ta diya jata. Election.
Otherwise, the paper books have been given to us. We are more or less ready with the paper book also.
Very well. You bring the health status?
Yes.
My lord, I am for the petitioner appellant. There was a custody trial and I was convicted under 304 part 1 for life and a fine of rupees 10,000. I'm in custody for 8 years, 2 months, my lord. There was a altercation between the brothers at home a day before the incident, and the prosecution case is that the accused hit the victim by the stone and accordingly he died.
Case of eyewitness, 2 eyewitnesses, 3 and 5.
My lord, no FSL, no serologist report. Even the blood were not matched. The blood stains which were taken from the cloth of the deceased, that was not matched. Recovery was not proper, my lord.
2 eyewitnesses.
Culpable homicide, not
Yes,
amounting to
stone,
murder,
stone was used on the head.
not amounting to murder.
The head was smashed with a stick. There was
So-
previous enmity. Thereafter, my lord, on the fateful day night, the child witness and the other PW3.
He was in the 8 years in custody.
What?
8 years.
That's true.
How much
He has
he has to?
languished in custody.
10 years. 10 years in
No, life.
life. What is you're not raising any objection, you're not saying anything.
No, but I have raised objection. PW3 and PW5
Or
and the
you are leaving the matter to discussion of this court. I am not.
when it comes to the fact of remaining in custody, that my lord, has to be a discussion of your lordships. My lord. We cannot.
When this file,
It is true that he is in custody for 8 years.
when
but
this matter,
the fact that this appeal was filed only in 2024, that is also
2023.
23 lordship.
this is 2023.
23.
is there
Judgment
any
was passed in
earlier
22.
rejection? Is there any earlier rejection?
No,
This
no,
is the
lord.
first time he has-
First time I am moving the bail application.
the
So
trial took some time.
whether the conviction is not correct according to you, what is that point? Conviction is not correct.
Lordship, I am challenging the
No,
conviction.
you are challenging. You give me some
Lordship,
bits and bits
the
so that we
seizure
can-
was not proper.
we can-
The stone which was seized.
Why it is not proper?
Lordship, I am coming. The stone which was seized, there was no signature of the witness on the stone or the label where the stone was there. Firstly,
But matching of blood stains.
blood was not matched. No serologist report, no FSL report. Even the blood stain which were found on the stone went to the FSL. FSL did not give any such report that it is the blood of the victim.
Of human blood. There's a observation that this is a human blood or not.
Lordship, even the
No, I am asking you whether material is available or not. And there are 2 eyewitnesses according to
interested witness, Lordship, one wife and other, no impartial witness was there. Lordship, not a single.
Even if the deposition of relatives raise confidence in the mind of the court.
I bow down to your Lordship, but there's a various discrepancy. If you go through the entire evidence, there are various discrepancy in the statement given by the wife and the son. The child witness was tutored by the mother. He was the step brother.
And my lord, the accused never had any intention to kill. It is a family affair.
Not this one. Issue. The applicant prays for suspension of sentence and grant of bail in an appeal filed by him against a judgment and order dated November 29, 2022, passed by the Learned Court of Additional District and Sessions Judge, Second Court, Sialda, South 24 Parganas, in Sessions Trial number 10, bracketed 02, bracket close 2018, upper bracketed R-1667 of 2017, bracket closed, whereby the appellant was convicted, was found guilty of committing offence punishable under section 304, bracket A, part -Roman 1, bracket close, of the Indian Penal Code, and was sentenced to suffer rigorous imprisonment for life, and also was directed to pay fine of rupees 10,000. Stop. Paragraph. The applicant says that he is in custody for 8 years.
8 years, 2 months, Lordship.
8 years, 2 months. Stop. Throughout the trial, he was in custody. Stop. There are several loopholes in the prosecution case. Stop. There is no forensic report
Evidence
was produced before the Learned Trial Court. Stop. There is no certainty as to when paper books are ready.
Lordship.
Yes, paper books are.
When the appeal will be heard. Stop. Hence, the applicant should be enlarged on bail pending disposal of the appeal. Paragraph. Opposing the prayer, Mr. Kesri, learned advocate for the state, points out that there are 2 eyewitnesses to the incident of to the incident. Stop. The head of the victim was crushed with a stone. Stop. There is sufficient evidence on record to support the judgment and order of conviction. Paragraph. Upon a perusal of the evidence and material on record, we find that there were 2 eyewitnesses to the incident. Stop. The incident happened within the household. Stop.
At 5 a.m. in the morning.
4 a.m. Lordship. 4 a.m. in the
4
morning.
a.m.
daylight was
At
there.
4 a.m. in the morning. Stop. Prima facie, there is sufficient incriminating material against the applicant. Stop. At this stage, we are not inclined to allow the applicant's prayer for suspension of sentence in view of the gravity of the offense, as also the material on record. Stop. Paragraph. Cran dismissed. Cran dismissed. Paragraph. However, considering that the appellant has been in custody for quite some time, we intend to hear out the appeal on an early date. Stop. We are told that paper books are ready. Stop.
TCR.
TCR nail
Yes,
paper.
without a TCR, paper books wouldn't.
Stop. Lists the appeal amongst the first 10 items. Next week.
Lordship.
As well.
Next week. এটা ধর।
এই ধরো এটা।
Milord, item number 16, Milord, I am appearing, Milord, one of the appellant. There are 12 persons. 12 persons, Milord, ultimately convicted under section 147, 148, 149, 302.
15.
16. Prosecution allegation goes like that. There was a dispute between the catching of fish in a pond. But Milord, thereafter, Milord, the color was added and it was turned down in a story of Milord political rivalry. And Milord, what's the difficulty, Milord, is this that PW1 and PW2, both these two with eyewitnesses, Milord, they are the sisters of the deceased. The first one, Milord, on the date when the assault was made, Milord, police came there, and thereafter, Milord, he was hospitalized. Thereafter, Milord, ultimately he was transferred to Bardhaman Medical College, but ultimately he succumbed to his injuries. But Milord, the thing is this: on the whole night, even the presence of the police, no FIR was lodged, nothing, even no journal diary, even. Thereafter, Milord, on the next day, when the court opens, Milord, the PW1 went to the court with the aid and advice of an learned advocate, Milord.
Political affiliation.
Milord, who has political affiliation, Milord, obviously, Milord submitted the FIR before the police station. This is Milord the
On
case.
the next day.
Milord?
On the next day.
On the next
On the
day.
next.
On the next day.
Milord, I am in 17, same judgment.
So you are.
We are all together. We three are together.
I
am opposing. Milord, there are 3 for the state, 3 for the appellants.
How many appeals are there?
Milord,
Two appeals.
Two appeals.
Milord, I am for 4.
How long
4
you are in
persons.
custody?
No, we were always on bail for 11 years roughly. Now, Milord, 2 years.
So it is not custody trial.
No.
Not at all.
So what are the allegations?
Milord, 14 persons admitted. 14 persons.
How many accused? 12 accused.
14 persons were named accused. 2 died within the course of the trial. Right, Milord. Milord, the only one thing I would like, as my learned friend has rightly said about the sisters being the alleged eyewitnesses, Milord, I will only rely on one thing. A person who took the body of this deceased to the hospital.
One victim.
One victim. Now, Milord, I will just place that part of it.
Is there any eyewitness or not?
Yes.
According to me, the eyewitnesses are related interested witnesses because it doesn't bear 14 persons.
Is there
Injury on the PM report is 4. What is seized is a bamboo. What is seized is a bamboo and a second. But I'll just place one judge.
Is there any possibility of presence of any independent witnesses considering the place of occurrence?
It should have been because it's 5 o'clock in the evening.
And why it was taken place?
Permanent?
Place of occurrence.
In the village, in the front of a house of Hira Sheikh. He was never examined. Hira Sheikh was never examined.
Not inside the house.
No, outside. But please seize this. I will not trouble your lordship. Seize this witness, PW16.
PW16 page number?
Yes, Malad. And apart from that, Malad, in respect of one of my convicts, Malad, a report was called for regarding his health condition. That Mr. Suman, they may tell your lordship. Oh, his health report is his CKD, Malad, as your lordship. Well, just seize this evidence.
Only one eyewitness.
No. All interested.
one.
দাঁড়া একটা মাইলটকে দেখায় একটা জিনিস।
Inquest.
Just read it.
Inquest report. Inquest witness.
Not inquest report. He taken the body to the hospital. Just seize. His evidence not declared hostile.
Cross-examined. Was my relative, my residence is near. Why you are showing this? He's not.
But he supports our case and has not been declared hostile by the prosecution.
3 witnesses have been declared hostile.
I know
This-
the accused persons, they are co-villagers, they are standing.
Well, just read it
Who I mean is the accused or victim.
Who, my lord?
I would.
Humayun is the deceased. Yes.
I know the accused, they are my co-villagers. They are standing in the court of the.
My lord, he was the first person after hearing he comes there.
Humayun died at Bardwan. At the relevant time of I was present there. The police of Bardwan conducted inquest and prepared a report of the dead body of. He did not mention about any incident.
That is what I'm trying to tell your lordship. And he was not declared hostile. That is what I'm trying to impress upon your lordship.
How I can know that he was present?
Because he took the body, he's there in the inquest. He took the body to the hospital. So he did not know about the incident. So nobody knows about the incident. And 11 years, my lord, I was on bail.
According to prosecution, he is one of the eyewitness.
No. But the eyewitnesses are PW1, PW2, PW4, and PW6.
My lord, if your lordship wants, I can answer those questions.
PW1.
PW1, 2, 4 and 6. 4 is an independent witness.
My lord, apart from that, my lord, let me finish one and then hear your lordship. I'll tell your lordship one thing. My learned friend has taken a very important point. Within 30 to 40 minutes of the incident taking place, the police appeared at the spot. Now, the police appeared at the spot. If we go by the timing, it's about 6 in the evening. The next day at 11:15 hours, the FIR was lodged. So, the entry of the police on that date would result in a conversation with the police by either the villagers or something of the victim's family, necessitating their arrival at the spot. So that's because the framework of the FIR, if a lordship sees, there are 14 persons. There are 14 persons who have been named in the FIR. Those were charge sheeted. Now, my lord, let me see the eyewitness. 1 and 2 eyewitnesses. My lord, if there are eyewitnesses, no, my lord, your lordship can see it. My lord, 1 and 2 are the alleged relative eyewitnesses. But I've given the copy of the evidence. Sister. One PC PW1, page 4 of the evidence. Cross-examination.
Page 4.
Yes, ma'am.
Yes.
In a page 4 on the top, your lordship see it. First line of the cross-examination.
I have no allegation against any person whose name has been mentioned by me in my deposition.
On the previous day.
What does it mean?
Means I am acquitted. Well, the presence of the police, how can it? The name did not transpire at that time. The name transpires after 16 hours. 14% assaulting, my lord, sees the injury.
Is there a political angle?
Yes. CPM and Tinumul. And the learned advocate who wrote this, he admits he's a CPM political activist. Well, this happened just after the transfer of power, 2013. And well, I was 11 years in custody, on bail.
Apart from 1 and 2, there are apart from PW1 and 2, there are PW4 and PW6. PW4 is an independent witness.
The accused belongs to which political party?
PMC.
Oh,
sorry.
No, I want to know. He's saying that there is a political angle.
But say that is the evidence I didn't find.
Yes, it is there, Mr. Shur. Even PW1 says the dispute arose in relation to a panchayat election.
Yes.
Regarding voting. That is there.
So there is no chance of abscondence because they are
11 years. Nobody's case that they ever abused or misused.
No, never.
Sorry.
Sorry.
Lordship, this petitioner Moharam Mir, he was granted default bail 90 days. Thereafter, he is in custody for about 2 years.
All of us.
Paper is ready.
True.
Mr. Shu, paper book is ready. There are appeals of 2015, 2013 which have to be heard.
Yes, ma'am.
So we can't take up all the appeals for hearing. It's not humanly possible. And what's appealing to us also, is it your case? Can you tell us he jumped any condition of bail? During bail, he committed
That
an
they don't
offense?
happen.
No.
Although I have not called for any report.
But ঠিক আছে।
No.
তাহলে তো মানে it would have been in the judgment itself.
16 and 17 together.
Yes, madam. Up to 17. 15, 16, 17.
15,
15 not sir.
16, 17.
16 and
Sorry, 16, 17.
Part 1 is 6.
So out of 14 accused, 2 died during
And
trial,
12?
12 convicted. All 12 have come.
Yes.
Different. The first appeal,
In
Millard,
2
relates
appeals.
to Maharam Mir 1 and Millard, the others, Millard.
Yes, all 2 have applied for suspension of sentence.
Malad, I am for 4. Malad, I am for Mir Libas,
One by
Pintabi.
one, no, it will be helpful for all of us.
Pardon, Malad?
16. Item number 16.
16 Millard.
Acha, sorry.
For
I get your
Maharam Mir. Mir Maharam.
No, Moharam Mir. Only one person.
One person only.
Only one.
And you are for how many persons? 4. So 5 out of 12 convicts have come.
আমি একজন মীর মিলন বাট আই এম ফর মীর মিলন
দাঁড়া না একটা করে বলছে my lord বলতে দে না আপনি মানে 16 your lordship takes up 16 first.
The learned counsel for the petitioner has submitted that the petitioner has been falsely sentenced, falsely implicated in this case due to political rivalry, and during the trial of the case, she was all along on bail. Stop. However, after conviction, after his conviction by virtue of the impugned judgment and order dated 2012-2023 / 22/12/2023 passed by learned additional sessions judge Rampurhat Birbhum in connection with sessions case number 127 of 2015. He has been in custody for about 2 years.
2 years.
Stop. However, there is no chance of an early conclusion of there is no chance of an early hearing of the appeal, and as such, he may be enlarged on bail on any condition after suspending his order of sentence. Stop. Para. The learned counsel for the state has opposed the prayer for bail and also suspension of sentence as made out by the petitioner. Stop. According to him, there are sufficient incriminating evidences against the present petitioner, and as such, he strongly opposes the prayer for bail. Stop. Para. It appears from the record that the petitioner was granted bail during trial, and there is no allegation that he misused his liberty during trial. Stop. It is also revealed from the materials on record there was a political rivalry between the concerned persons. However, as the petitioner did not misuse his liberty during the pendency of the trial, we are inclined to,
and admittedly, there being a political angle.
We are inclined to allow the prayer for bail on the consideration that there is no chance of an early hearing of this appeal. Stop. In view of that, বলে যেটা আমাদের আছে
ACJM
কাছে আছে format.
মানে ACJM Rampurhat.
ACJM Rampurhat, and he shall meet the OC Where is he staying?
My Rampur RPS. Rampur RPS.
Rampur RPS once in a fortnight until further order.
Once in a month.
Man, make it once in a month. Asking too much.
Once in a month.
One.
We are passing order in his prayer. Why you are interfering?
Same prayer. But a cut, paste. Names change, cut, paste.
Not leave.
Acha, but then Birbhum district. Without the leave of the ice.
ওগুলো সব আছে ফরম্যাটের ভিতরে আছে
Only one thing, he got statutory bail. Only that statutory.
Birbhum.
Not bail, statutory.
You never applied for cancellation of that.
Because statutory bail is right.
It can be done.
Statutory right.
No, after that.
Not to leave district Birbhum. ঠিক আছে?
Well, without the leave or something.
Without the leave of the OC Rampur RPS.
He was on bail during trial না ওটা statutory bail করেছে
Because the can is disposed of.
Yes. Next.
OC হবে না IC রামপুরহাট হবে
না না
43 এটা আমরা
চাচ্ছি যে ক্র্যানটা আছে ক্র্যান 2 of 2024 এবারে 17 এর যে ক্র্যান in 17 there are two crans why
yes one is mine and one is his
oh
two appeals
All the accused persons are not by the application.
Can one
না আমরা চারজন করেছি
দেখে নেবে
ফুলবাস করিনি আমি না হ্যাঁ মুভ করিনি মাইলট জিজ্ঞেস করো 6 জন হয়েছে খালি 6 জন ফাইল করেছি মাইলট in that মাইলট 40 of 24 CRA 20 that's 70 মাইলট
3 of 24 yes
there are মাইলট 4 per Libash me Mithun Sheikh alias Firoz Sheikh and Malad Sujan Sheikh alias Ashrafur. Well, I'll give the note, Malad. I mean, note.
And Malad, I am for another person.
The actor says for get
one by one.
Sorry, Malad, we are sorry.
Problem. There will be problem.
Sorry, Malad, sorry.
In 7, how many one petition? 4 persons.
4 persons.
Yours is cran 1 or cran 2?
One, cran 1.
Can please tell the names.
এটা নিয়ে দাও তো এই দেখো প্রথম 4 জনের নাম আছে দেখো উপরে লেখা দেখো সিআরএ লেখা উপরে 4 জনের নাম আছে
তুমি দিয়ে দাও ওটা
and another cran number 2
Can number 2
how many accused are
only
there
one Malad Mir Milan alias Milan Mir.
এতে একই
Appellant number 11.
ঠিক আছে এগুলো এইভাবে হবে হয়ে গেল
বাকি সব এক হবে
একটাই হয়ে যাবে
excepting your clients were on bail not statutory bail
all was statutory all was statutory
statutory
আমি statutory জজ সাহেবের জাজমেন্টে লিখেছে তুই দেখ না তুই জজ সাহেবের জাজমেন্টটা দেখ না সি দ্য জাজমেন্ট
Lordship will kindly turn to the judgment.
90 দিয়ে সব লিখে দিয়েছে মানে at page 3 of the judgment all the date numbers when they were how many days of 24 28 everything has been written I am grateful to you grateful chalo এই তোমার কিছু প্রবলেম হলে বলো আমাকে হ্যাঁ আমাকে জানিও কিছু যদি প্রবলেম
না এই সংক্রান্ত
well now it looks like your lordship maturing enough
why what happened
after that Malad after number 5 Malad
what is number 5 this is
number 5
court number 8
Malad
this is court number 8
I know 5 serial number sorry man sorry
দশটা কানেকশন প্রাইভেট চেম্বার যাবে ইমিডিয়েট
চারটের মধ্যে আচ্ছা সাড়ে চারটে তো
ছিল কিন্তু মোটামুটি আইডিয়া পেয়ে যাবে আজকের এগুলো বুঝতে পারছি না এগুলো তো পাবে যাবে কাছ থেকে আপনাকে পাঠিয়ে যে বেলগুলো থাকবে সেগুলো তার থেকে খান পাঁচে কাম
আমাকে যেটা পাঠালে দশটা
আমাকে ব্যাড গুলো দেবে আর আরো 5টা দেবে
আমার হ্যাঁ পরের পাঁচটা তারপরে
ঠিক আছে প্রতিদিন আমি কাজ করবো একটা
Well, the second time I'm filing this application for suspension of sentence. It was rejected earlier. My lord, case is under section, my lord, 376, conviction under section 376 2F and 4 of the POCSO Act.
De facto,
10 years.
Victim.
Victim, my lord, I think Division Bench of Justice Sen, if your lordship kindly see the order, directed the legal authority to appoint, kindly see, my lord. It is my understanding, my lord, my instruction is this. Division Bench of Justice Sen, my lord, directed.
So have you served upon the victim or not?
Well, initially I have served. Thereafter, as directed, first when I moved the first bill application, I served. Then, my lord, initially, then my lord, when Justice Sen directed, Division Bench of Justice Sen directed for appointment from legal aid, then I have not served.
Where is such direction? We don't find.
That is not in the record.
Shall be entered. Victim shall
Well,
be
that is not in the record.
The victim shall be entitled to free.
That is not in the record, my lord. I am asking a question myself.
Maybe yes, it is there. It is there, but that was in connection with CRAN 1.
CRAN 1.
This is a new CRAN.
New CRAN.
You have to serve it on the victim. You have to. 376, section 4.
Well, again,
what is the age of the victim?
Well, at that point of time, 17 years.
And the age of the accused?
Well, the accused, 53 years.
53 years. So there is no.
But if you lordship kindly, 7 witnesses examined. Well, my nicety of case is this, my lord. It has been stated.
Whether you serve and come back. Submission on merits. The appellant oblique applicant was convicted under section 376 2F
and 4
of the IPC, read with section 4 of the POCSO Purota, and was sentenced to
10 years.
Undergo rigorous imprisonment for 10 years, by a judgment and order dated January 9, 2024, passed by the learned court of additional sessions judge, comma, second court, comma, Chinchura, comma, Hooghly. Stop. Paragraph. The appellant renews his prayer for suspension of sentence and grant of bail, comma, which was rejected earlier by a coordinate bench by
25th,
an order dated
20, last order on 20.
January 2, comma, 2025. 2nd January.
2nd January.
2025. Paragraph. Let service of this application be effected on the victim girl and affidavit of service be filed in court on the next date. Paragraph. List the matter.
Well, as early as possible within 7 days.
Yes.
Well, I'll serve today. I'll serve
Next Monday.
next Monday.
At the same position.
Well, leave your place.
Item 19. 20.
My lord, I am praying for not today.
On the prayer made on behalf of the appellant oblique applicant, comma, let this matter stand adjourned for the day.
Your service then.
Oh, have you served, Rukiji? Yeah.
My lord, I am led by Mr. Shuman Chakraborty.
You're not appearing in this matter?
I am not advocate on record.
So you will not know anything about the matter. Their matter will be delayed. What can be done?
Yes.
Grateful, Lord.
I'm for the appellant.
21.
I'm for the
change kodo.
But POXO, but my lord, victim died, complainant died. After that, appeal was admitted, and none is there. My lord, she is 55 the order.
Page what? See?
55
of the bail application.
This is renewal.
No. First,
Why CRAN 2? What was CRAN 1?
CRAN 1 condemnation of
Delay was there. Four.
I see. How long are you in custody?
I am in custody for 9 years and 6 months, 20 years custody, man. 20 years punishment. He is a handicapped.
Years offense, my lord. PW
Committed rape and murder.
No. Only there. Only there.
supported by medical evidence. PW 12, page 25.
9 years, 6 months, my lord. Kindly consider this.
Page 25.
What is your age?
At 46, I was
46 and he is
Student
he
of
was
class
11
4,
years.
11 years.
But
in
terms of
it was passed by
Swadhan Singh, my lord, I'm
Swadhan Singh. We shall
Paperbooks ready, my lord. It's ready for hearing.
PW who?
PW 12 is a doctor, my lord. Page 25. The inner page 11, my lord, of the judgment. First paragraph, my lord.
but petitioner is a handicap and suffering from various ailments, my lord.
Tell me what is the wrong in the judgment first.
If my lord, I'm not on merits, my lord. I'm not on merits, my lord. In terms of
I am on ready.
lordship,
No, I
in,
have
in terms of Swadan Singh, my lord, I'm praying for bail.
What does Swadan Singh say?
Half of 10%.
What does Swadan Singh say?
At 8 years punishment, if appeal is not ready, it is ready for hearing. I know, my lord. But so far, I am concerned, my lord. I am pressing for 436A. If your lordship kindly considers.
It is not that after your conviction you are in custody for 8 years.
No.
9 years.
No. It
was custody trial.
Custody trial. It was.
Conviction was in the year 2022.
Yes,
July 2022.
Custody trial.
Of 580
9 years, 6 months in custody. My contention is
He has to remain in the custody for life. Why you are saying
20 years. Part in
and on the supposition that the conviction is wrong.
No, 20 years part.
That is different,
Yes,
sir. We are now convict. It is not an bail application during trial.
My term imprisonment.
2020
Term imprisonment, my lord.
Kindly. This was wrongly. There's a manifest irregularities. Everything you have to show.
Lordship,
come back with the.
my lord, kindly, here's my point, my lord. In terms of 436A, my lord, if half of the punishment is suffers, but in term imprisonment, almost half of the punishment, 9 years, 6 months. But on that ground, my lord, I'm praying for bail. My lord, kindly here's my appeal thereafter, my lord.
There is a POCSO of matters.
That is true. That is true.
We have to,
but on the other hand,
we have to consider.
I have suffered 9 years, 6 months, my lord. My lord, my son is also suffering.
The death of the victim was not because of the
no
incident, unrelated.
Yes, my
conviction of 2022 before 2020.
Sufficient. Victim complainant have died. In spite of service, father of the victim.
But my son is also suffering.
What is your submission, sir?
My lord, half of the imprisonment he cannot claim because, my lord, it's a 2022 conviction. He papered appeal after 2 years. 2 years already gone in the meantime, my lord.
My lord,
in the meantime,
just a minute.
Sorry.
My lord, PW2 is a victim provided by PW3 and medical officer. Well, specific allegation. He said, my lord, is a high, my lord, forcibly penetrative, my lord, assault in the private part.
So are you ready with the hearing of the appeal?
But today I'm not ready, my lord.
Today I'm
But kindly enlarge me on bail.
only
Thereafter,
bail, then no.
No, my lord. I'll move this appeal, my lord, for some days, my lord. Just for some days.
It's a 11 years child. We cannot.
But for some days, my lord. Kindly, my lord. Appeal is continuation. So, my lord, I'm just placing, my lord.
It's not a normal.
Continuation of the trial, my lord. Kindly consider this, my lord.
We are considering that one additional sessions judge has convicted him.
That is true, my
lord. That additional session judge, after
according to merit,
becoming the judicial magistrate,
I'm not
then
on
assistant sub-judge, then.
But I'm not on merit, my lord. Just on that
But you are not on
technical
merit, but
point.
I am on merit. The 11 years child, how can we? I do not know whether my brother will say.
There are certain irregularities, my lord.
You come back prepared for the appeal next week. We'll give you precedence. We'll hear. No,
But
no, we are
for-
reading
for-
the evidence of
my
the victim girl.
lord, I have read this, my lord, for some days. My lord, I am suffering for various ailments, my lord. Kindly
No, that ailment will direct the correctional home to, yes, to do everything that you need.
This is not a bail application under section 439.
uh,
No,
that
I'm
is
saying that.
yes, my lord. Yes, my lord. What I was trying to press, my lord, 436A and continuation of trial, if half of the punishment
No,
is
we are
that technical ground.
hearing.
The applicant prays for suspension of sentence and grant of bail pending disposal of the appeal. Stop. He was convicted by the learned special court under POCSO Act, come additional district sessions judge, come additional sessions judge, comma second court, comma Howrah, by a judgment and order dated July 27, 2022, passed in special TR number 30 of 2016. Stop. The conviction was under 4 or 6, section 6 of the POCSO Act. Stop. He was sentenced to suffer rigorous imprisonment for a term of 20 years and also to pay a fine of rupees 50,000. Stop. Paragraph. The applicant says that he is in custody for more than 9 years, 6 months. Stop. Considering the provisions of section 436 capital A CRPC, comma, he should be granted bail pending disposal of the appeal. Stop. He suffers from various health issues which need immediate medical attention. Stop. Paragraph. Learned state advocate opposes the prayer. Stop. He draws our attention to the deposition of the victim girl as well as the doctor who examined the victim girl, being PW2 and PW12 respectively. Stop. Paragraph. We, having gone through the evidence on record, comma, prima facie it appears that there is sufficient material on record to evidence on record to support the conviction of the applicant. Stop. The victim girl was all of 11 years old at the time of the alleged incident. Stop. The manner in which the victim girl was ravished, as narrated by her in her deposition, comma, is prima facie culpable. Stop. We are not inclined to extend the privilege of suspension of sentence and grant of bail to the applicant. Stop. Paragraph. Granted dismiss karo. Paragraph. However, comma, considering the length of detention of the petitioner in judicial custody, comma, we intend to hear out the appeal, giving it precedence. Stop. List the appeal under the appropriate heading amongst the first 10 items. Next week, paper books are ready.
Yes.
Good.
Rejected.
No है। अरे अटका अटका होता है
21.
Where's your learned friend? From a departmental note dated 7th of November, which is what? আজকে কত তারিখ?
Today is 10th.
That note says,
Within 6 years.
yes, paper books are not ready. Mr. Ganguly, why did you say it's ready?
List.
The note says within 6 weeks it will be ready.
After 6 weeks, okay. Inform me.
Inform your friend, learned friend. This next week করো না, paper বই হয়নি তো।
Complete straight January.
This is the matter after 6 weeks. As 6 weeks, as we find from a departmental note dated November 7, 2025, that paper book is yet to be prepared. Stop. The note, in the note, comma, a prayer is made for 6 weeks' time to prepare the paper book. Please inform him.
My lord, I beg to appear for the victim. The application for bail has not been served upon us, my lord. My lord, kindly fixes a date for hearing.
Can it be on 13 minutes?
13th.
Are you serving in the course of it?
For the suspension or for the main hearing?
No, suspension. Learned advocate for the, how long are you in custody?
Out of 12 years, 8 years, 5 months.
Oh, Baba. Learned advocate for the victim girl, this is POXO,
Yes.
says that he has not received a copy of
Hey, 23, my lord, I am. 23 and 24. I am for the 24. Read by Mr. Bhupender.
who's in 23.
23, my lord, I am.
You're there.
23, my lord. What's
You are in 24.
4 years.
Yes.
Both arise out of the.
You are for the state in both.
I'm there in 23.
1924, I am for the
20?
24.
Very well. One by one. Yes.
Lord, the maximum conviction in this sentence is 10 years. Out of 10 years, today we have completed exactly 8 years.
What is the charge?
My lord, there was conviction under 7 heads, 9 heads. 7 heads sentence has been served. Only 6 and 17 POXO and 370 of the IPC. Now, my lord, POXO with regard to me, the girl is not a minor.
আমি তো নোটও করি
25
কি দিয়েছে
না
এটা কে দিবে এটা বাজে একটা দিয়ে
Yes, well, it's a legal aid matter. Case under initially case was started under section 498 at 302. Well, charge also framed on 498 at 302, but conviction has been given by the learned session judge only 302. My lord, learned judge disbelieved so far 498 is concerned. My lord, is a
charge was framed under section
498 at 302.
Okay.
But learned judge, so far, my lord, charge, so far, my lord, 498 is concerned, disbelieve the entire story of the prosecution. That's why he acquitted, so far, 498 is concerned, 302, he was convicted.
It is not a dowry death or something like that.
Yes. My lord, there is an allegation that 16 years back, my lord, marriage was solemnized with the victim and the husband, my lord, this appellant's elder brother. And my lord, during his my lord, matrimonial house, he was subjected to torture. On the fateful day on 8 January 2016, my lord, there is a phone call from the PW6. He is a daughter of the victim to the de facto complainant that his mother was assaulted by her in-laws, not the my lord appellant, only my lord in-laws. My lord, case was started during trial. Nobody, my lord, support the prosecution except the PW6, daughter of the my lord victim. He is aged about
PW6 has stated.
PW6
with spade and her.
Yes, my lord.
With her mother's hair with a spade.
So with a spade, this is the
And
my
her
lord, so
mother
far
fell down
PW, so far
and-
during my lord investigation, he is not an eyewitness. My lord, so far, my lord, PW7 is his brother, PW6, my lord, brother, he, my lord, victim sons. My lord, he stated that PW7 along with PW6 at the time of incident was in
Why is the evidence?
school.
Why is the evidence? I do not find.
Yes, my lord.
Evidence.
PW. Only it's a
No, you did not enclose.
Well, kindly see the PW7.
Copy.
Oh,
Required.
one copy.
No.
May I make it not today? I provide 2 copies. My lord, learned judge even not even discuss, my lord, any witness. Nobody support the prosecution. Only basis of PW6 conviction given and 7 years he is in custody.
What is your submission, sir?
My lord, first
We
of
do
all,
not
my
find
lord,
a detailed discussion is not there.
no, page 2, my lord, the charge has been framed under section 302 only, not 498. Page 2 of the inner page. And my lord,
there is no detailed discussion.
My lord, that the spade was required from the house of the appellant. First, the injuries, my lord, categorically supported by the doctor because the injuries in her head. And thereafter, my lord, PW6 and 7, the daughter and son, the 6 is the eyewitness of the incident. My lord, she stated that, and 7 stated the character of the appellant. He used to consume ganja. He used to ask the appellant for money, and thereafter she disagreed with that, and she started beating the lady.
So his
My lord,
uncle.
yes, my lord, the husband of this appellant, my lord, he is not here. He is out of station because of his work. So she was there with his 2 children, and this person continuously, my lord,
PW7 is concerned, his cross-examination, at the time of incident, he was in his school along with PW.
How long are you in custody?
7
7 years. It's a legal.
It was you were on bail during trial.
Yes, Martin.
Yes,
He was on
Post-conviction custody. He
bail.
was on bail.
Paper book is ready. my lord.
Yes, sir.
Please, sir.
Are you saying that he jumped conditions of bail or abused the privilege of bail?
That information I don't.
7 years already post-conviction. Esho. The applicant prays for suspension of sentence and grant of bail. Stop. He was convicted convicted under section 302 of the IPC by a judgment and order dated May 7, 2018, passed by the learned additional district and sessions judge, fast track court Roman 1, Diamond Harbour, South 24 Parganas, in sessions serial case number 26 bracket 4 bracket close 16. Stop. He was sentenced life imprisonment to suffer rigorous imprisonment for life and was also fined. Stop. Paragraph. The applicant says that post-conviction, he is in custody for more than 7 years. Stop. Throughout the trial, he was on bail. Stop. He never jumped any condition of bail. Stop. He did not abuse or misuse the privilege of bail. Stop. There is no certainty that the appeal will be. Appeal was preferred after 7 years, 6 years.
Yes, there are limitation.
There is a limitation. It is filed by legal.
Appeal equivalent is that the appeal will be heard on an early date. Stop. Hence this application. Paragraph. Opposing the prayer, learned State Council tells us that there is an eyewitness to the incident. Stop. PW6, being the daughter, the elder daughter of the victim lady, is the eyewitness. Stop. There are also other incriminating evidence against the appellant. Stop. Hence, the appellant's prayer should not be allowed. Paragraph. We have considered the facts and circumstances of the case and the material on record. Stop. It is not in dispute that the applicant was throughout on bail during the trial. Stop. It is not the case of the state that the applicant misused the privilege of bail or jumped any condition of bail. Stop. Further, paragraph 2. Further, this is an appeal of 2024.
No,
Stop.
No, 18 sal.
Appeals much prior in point of time. Appeals filed much prior in point of time are yet to be heard. Stop. Hence, it is unlikely that the present appeal will be heard on an early date. Paragraph. In view of the aforesaid and on an overall appreciation of the facts and circumstances of the case and prima facie assimilation of the evidence on record, keeping in mind that the applicant was on bail throughout the trial, we are inclined to allow his prayer. Usual condition 30 days. No, satisfaction of
ACGM Diamond Harbour.
Where does he stay? Will not leave that area.
Usti Police Station. Usti Police Station.
Report to Usti Police Station, jeta ache korbe.
South District South 24.
Will not leave South 24 Parganas without the permission of the IC Usti Police Station, except for attending court proceeding.
Grateful one. Yeah, two and video to
NDPS. Yes, unnecessary NDPS. Fine, something.
Ganja, heroin, what is it?
Gaja.
Yeah.
I find some
26 to 28. 26, Lordship, I am for the appellant.
My lord, I am in item 28.
Ekta slip ta debe, ekta slip debe.
I am in 27. 7 years.
Shobik. 27 Shobik there.
Why the judgment was wrong?
Lordship, I am telling.
You are.
I am in 26.
26.
Lordship, in this case, PW1.
How long you are in custody?
26 state.
6 my lord.
Joydeep. না আমার সাথে জয়দীপ দা 26 স্টেট তুমি এই তো স্টেট
How long you are in custody?
4.5 years
Only.
And sentences?
14 years.
14 years.
Now, Lordship, I am telling on merit. Prosecution case is this. As per PW1, the seizing officer plus FIR maker. PW2 and 3, the raiding party member. That on the date of incident, at about 4:55 hours, they found a lorry came and parked at the eastern side of NS34 near Bethuadori. Police team waited there. At 5:25 hours, another Scorpio car came and just parked beside the truck.
Have you enclosed evidences?
Lordship, the paper book is there. Lordship can find it from the paper book. Now, police found 2 persons inside the truck and police found 4 persons inside the Scorpio vehicle. No one get down from the vehicle as per PW 1, 2, 3.
No one get down on 2 vehicles.
2 vehicles as per PW 1, 2, 3.
So they are watching that whether they are
Now,
watched by
before
police
they
or
get down from the vehicle, PW1 along with other officer intercepted both the vehicle. Thereafter, the person inside the Scorpio car got down from the vehicle in presence of police.
because the police got the information. That's why.
Lordship,
police got the information.
No, police was
That's why they encircled.
Got the information and police encircled. Now, from the person Scorpio car got down from the vehicle in
What is his name?
The present appellant Johuruddin, all the present appellant in the these 3 appeals were in the Scorpio car.
Yes.
And the person who are in the truck are Shahabul Sheikh and Shaher Ali.
Okay.
Now, after that, police searched the truck. That truck, 525 kgs of gaja was recovered. 525 kgs of gaja was recovered. 525 kgs of gaja was recovered from the truck. Now, there is only 2 independent witnesses as per seizure list. Prosecution examined only 1 independent witness, and that independent witness has been declared hostile by the prosecution. Now, entire prosecution case is now relying upon all the police witness who are the member of the raiding team. Now, Lordship, as per PW1 and the investigating officer,
the videography was done.
No. As per PW1 and the investigating officer, inventory was prepared at the spot and subsequently before the magistrate also. But investigating officer specifically said he sent the sample for test which was prepared at the spot, not before the magistrate. Now, at the highway, Lordship knows better than...
Very daring appeal.
No, I'm placing that whether I have an arguable case or not, because that is the main criteria subject to approval by your Lordship. Now, there is no telephonic conversation or CDR which was placed on record with those 2 who are in the truck along with the present appellant.
What is your profession?
We are all, just a minute, I have stated specifically in my...
What is your profession?
Just a minute, I am specifically stating from...
This question from syllabus.
No, day labor.
Day labor.
52 years old, day labor.
And using Scorpio.
No, Lordship, not using that. Not Lordship knows better than me. In highways, all the cars flies in share basis.
Day labor is riding Scorpio. Why?
Scorpio is not his own Scorpio.
Whatever he has taken to unload, upload.
No, not for unload, upload. Lordship, the Scorpio was also coming.
That is raising this question. Please, we have separate question for you. Don't worry.
Same, we are all traveling on the same boat, my lord.
And my lord,
It's all day laborers.
no, item 28 is a driver.
Please.
Lordship knows better than me. In highways, NH 34, that is Kolkata Siliguri highway, all the private cars run as shuttle from Bethua Dahudi to this place.
Why you are riding? Why you are riding?
I took
Why? What is the reason that you are going to attend some invitation? Or why you are there? This is not bail application.
Strategy section 37 wouldn't apply at this stage.
Lordship, subject to correction, no, 37 is not applied. That is 37, 32.
37 bar will not apply.
No, at this stage not apply because 32 is there, which was subsequently said by the Honorable Apex Court as overruled. The 32 to 32A, Honorable Supreme Court overruled that.
37.
37.
Paper book ready.
Paper book ready.
We'll hear out the appeal. This is good.
Well, something. Well, I was granted with a specific condition.
Is it 27 or 20?
I have done so.
27 or 28?
Shatash.
27.
I have complied with the order of the honorable.
So you are on interim bail?
I was. I was directed to surrender. I have done so.
No, why? Some happening was there? Anybody died or?
House, my lord, in the family, marriage in the family.
That's why.
And what I am on the conduct, my lord. I was granted interim bail. I attended the marriage. 15 days. I again came back. I surrendered on my petition. I did not run away.
You
So
will
the
not give
question
some.
of flight risk.
Just please. Yes.
The question of flight risk, one of the parameters for grant of bail, that does not exist so far as I am concerned.
Question of resumption of your business remains.
What is he
Once
doing?
you're late.
Deliver.
My lord, no, I am not a grade level.
What is your profession?
That instruction.
That instruction is not available. Separate questions.
Transportation and
Transportation.
I have a house. I have lent out the house on rent, and I have a business of transport also.
Oh, business of transportation.
Transportation, and I have house which I have let out on rent. Now,
Which for the state for his 27? Yes, tell me.
so far as my lord, these are the preliminary facts which he was, my lord, articulating on. Issue is, my lord, there is nothing to show that between the Scorpio from which these persons were arrested, there was any unloading or loading.
What is yours?
My lord, item 28, the appellant is a driver of the Scorpio. My lord, he was the driver, these three persons.
Who is the owner?
My lord, the owner, that name has not transcribed.
So you being a driver, you do not know the name of the owner?
My lord, I was the owner of the vehicle.
Said each of you have separate question. You will get separate question paper. So you being a driver, you do not know the name of the owner.
My lord, Shomir Das.
Instruction and come back.
My lord, that will be.
No, we shall reject. Anything? Yes, please. Yes.
My lord,
the learned counsel for the petitioner has submitted.
My lord, item 28 may come back with instruction.
No instruction. We are.
Now, before you
I have instruction.
Before you lost.
I have instruction to reject.
Lordship, before your lordship pass order, may I submit one thing?
What can be done?
Before your lordship dictates the order.
26.
Before your lordship.
In a similar circumstance, in a conviction of 10 years, my lord, where 400 and plus kgs of 468 kgs of ganja was, my lord, found. The High Court had bail in connection with the appeal that went up to the Supreme Court, and the Supreme Court, my lord, granted bail. And in this, that was 6.5 and 4.5. Similar situation.
The appellant has undergone 6 years, 2 months, and 10 days of imprisonment. We do not undermine the seriousness. The only concern we can express today is that appeal being such. So we are ready to hear.
And in Lakwinder Singh,
Lordship, another
same.
Planet Council.
Lordship, prior to that, Lordship,
that petitioner
Lordship, kindly,
custody for about 4 years, 6 months. 4 years, 6 months.
kindly,
And
Lordship, just for 1 minute.
he is one of the daily laborers.
Lordship, I am placing a judgment of the Supreme Court. Kindly see.
Yes, given this.
No, another judgment. But the same case where the mother seized article were not produced and the punch witness, that is the independent seizure witness, declared hostile. The Honorable Apex Court has been pleased to set aside the entire conviction. Your Lordship will find at paragraph, I am just placing only one paragraph, paragraph 10, 11 and 12. Very short judgment, Lordship, kindly see. Paragraph 10, 11 and 12. And this case is also same. The main goods were not never produced before the court and the independent witness declared hostile.
Was not produced?
No. Only the samples were exhibited.
And the 52A was not.
The evidence. The evidence is nothing.
Lordship, kindly come to my third page of the copy I have given to your Lordship. Your Lordship will see the list of exhibit.
Third page of
that. The judgment I have.
No. You have in our case whether
no, I have made.
Alamas have been produced or not. Sample produced or not.
No.
Seized goods were not produced.
Samples were produced.
Take instruction and come back. Take instruction.
Kindly come to page 50.
Page 50 of the.
At the top, your Lordship will get.
You all this page 50.
Page 50.
Yes, page 50.
At the bottom, 50.
I read of the judgment.
Yes.
Please read.
Lordship, what is the present case? It also appears that there are some disputes.
In hand. Please read.
Lordship, kindly says. In this case, evidence of the prosecution witnesses at the bottom.
Yes.
Are cogent, convincing, trustworthy. There is no reason to dismiss the prosecution witnesses. All the prosecution witnesses stated in their evidence that they apprehended 6 persons and also.
So it was not disputed, but from the four corners of the oral and it is not disputed that 525 kg of ganja was recovered from a truck such and such. You did not deny.
Lordship, it was
according to them, and 6 persons were assembled. So you did not deny.
Lordship, the IO says otherwise.
Where is the ganja?
Where is the ganja?
It is not that the 525 kg of ganja will be produced before the court.
That is what
sample. Only sample will be.
No. The judgment I have relied upon. The judgment I have relied upon said so. Lordship, kindly see. The judgment I have relied upon Vijay
So
Jain
you
said
take
so.
instruction. দেখতে হবে কিন্তু না দিয়ে আমি তুমি করে দিতে পারবো
দেখো
Vijay Jain is specific.
He has to meet your case. They are saying that no certificate was produced before the court.
Lordship, the kindly see the independent witness PW6.
They are not ready. Are you ready, Mr. Vishwas?
Lord, more or less from the judgments which I find, Lord, page 131 of the paper book. Lord, here the learned.
Whether certificate has been produced.
It was law. Now, my Lord, here the learned judge comes to a conclusion before passing the sentence.
So they are raising this point on the basis of certain judicial decisions of the Honorable Supreme Court. So we have to deal with all these things.
In the paper, the exhibit list is there.
Vijay Jain's case that Mr. Chatterjee has handed up, seized material has to be produced and exhibited. And if not, then acceptable explanation has to be furnished.
Yes,
why it was not. Consider and come back.
The judgment on page 131 of the paper book.
No. This is very vital.
As to no reasons were given why so much of contraband was given from them, the defense could not produce any reason.
To us.
That is from page 131 of the paper.
Whether it has been produced or not. Certificate has been produced or not.
Page 49 of the judgment, your lordship kindly.
No. This is the law. Prosecution cannot depend upon the weakness of the defense.
Obliged.
You have to show
I understand what is
That
calling.
525 was seized. So he is taking time.
I understand what is calling from.
Third learned
Any day apart from
Thursday, Friday, Friday,
Friday,
26, 27, 28 একসাথেই করো. Heard learned counsel for the applicants
So he
as well as learned counsel for the
give
state.
copies of judgment.
Paragraph.
Otherwise, there again.
Learned counsel for the state seek a little time to consider the case laws cited by learned counsel for the applicants. So paragraph lists these matters once again on Friday date.
520.
My lord has a different bench at 1 o'clock. We'll come back at 2 o'clock.
At 12:45, one matter is fixed.
Yes, that can't be. Our officers have goofed it up.
Then can you fix another date?
Yes. দেখেছো তো কি অসুবিধা হচ্ছে?
Advocate general will be appearing against me.
Oh. Huh? What is it?
2 p.m.
What happened?
No adverse. Mr. Devashish, they.
No, that is not.
No, no, no.
That is we cannot explain. We cannot explain.
2 o'clock then, if you are willing to appear. Are you willing to appear at 2 o'clock?
2 o'clock, we would have a matter fixed. Kindly keep it some other day, subject to your lordship's business.
You tell us, kholo, khata kholo. Tell us.
Can my learned senior
Oh.
I cannot, after reading the resolution, I cannot make head and tail of that.
Even disclose the reason. Your lordship will get it on WhatsApp. Why do you need the reasons? You must know the result or the effect of it.
13th. Thursday, na? 13th was it? Thursday.
At 2 or in the morning or any time, my lord?
Same time?
12:45.
12:45. Good enough. We'll come back at then if you appear, we'll hear you. If you don't, if you disappear, we'll rise.
Great.
এগুলো বাড়ি ওখানে আমার
Your Lordship, may I be permitted to mention a matter?
Is this the mentioning time?
Your Lordship, we had a 3:30 fixed matter before Your Lordship, and there's a resolution for 3:30 p.m. today. I'm
Let
let
3:30. Huh? Matter. Keshe. Oh, I see.
Your Lordship,
Mr. S.N. Mukherjee was appearing.
yes, Your Lordship, yes. I was praying, Your Lordship, that the matter could be fixed tomorrow at 3 or 3:30 p.m. as per Your Lordship's convenience.
But that matter was heard before this bench,
Yes, Your Lordship.
not before the
No,
other bench.
Your Lordship, on the last occasion had passed an order also. So
দেখো কাল পরশু কি অবস্থা দেখো
tomorrow at 3 p.m.
ওই সেইটা তো
last time 70 না তাহলে কালকে শুনি ছেড়ে দিচ্ছি tomorrow who's on your other side?
We have served the mentioning notice. We have spoken to the
Sir, all
advocate.
very well, but then when did you serve?
My lord, the mentioning notice was served at around 1:15 p.m. My lord, he had come to court. He met me. He said that if you have to fix the matter, fix it at 3 p.m. tomorrow. That is the word from the advocate on record for the other side.
3:30 tomorrow.
3:30, your lordship, tomorrow.
3:30.
My lord, I'm tendering apology, my lord. I went, Mr. Sengut.
No problem. The problem is that no paper book has been prepared.
Yes, my lord. That's
so
why
we found a departmental note
Yes, my lord.
dated 7th of November, which is last Friday. Department has asked for 6 weeks time.
Yes, my lord.
So we have listed it after 6 weeks.
In that case, my lord, I am entitled to bail, my lord, as per the judgment of Southern Singh. But kindly, my lord.
we shall reject. Bring that record, we shall reject. Okay, with reasons.
Reject to Puri.
My lord,
29.
No.
But I know, my lord, on merit matter is bad, my lord, but if paper book is not ready, 9 years, 3 months, part imprisonment, my lord, kindly consider it. 6 months, 9 years, 6 months, part imprisonment.
Order.
That is true, my lord.
In spite of that, how long you have practiced here?
No,
I want to know from you. Tell me. We have passed our order. Next, din kasum.
29 and 30.
চলো যা থাকলে কিছু করতে not today হয়ে যাবে
31, 32 to 35, 36.
কত 30 to 36 32 to 36 মানে কত অ্যাপেলেন্ট মাল স্টেট আছে কে আছে
your resolution
Mr. Shu.
It is a rather intriguing resolution. Firstly, request is to rise at 3:30. Then it says some members will go to visit the
I have seen it.
channel.
Embarrassing.
Then it says Vande Mataram celebration.
10,000 members or 15,000 members.
This was precisely why, my lord, before the recess, we could not spell out the reasons.
Anyway, what to do? Not today. What else?
No, not today.
Not today. এইগুলো যেন পজিশন ঠিক থাকে হ্যাঁ কালকে
$37, 38 to 41.
38 not done first.
38 to 41.
38.
38.
38.
37 minutes, I was 40.
Are both sides here?
Miss Onusha Sinha is for the state.
Yes.
She was there in the morning.
Huh?
She was there in the morning, Malad, in the first.
She was there in the morning. Presently, she is not there. So tell us what we should do. Pass it over. If we can get her, we have no problem. We'll take it up.
But may I give her a call? My lordship keeps it as a passover matter.
Passover. 38 to 41, Mr. Tiwari.
38 is
38 Miller I am appearing, but rest of the
Just see if your other side is here.
no other
Then
side.
we can't take it up. It's your request, your resolution.
Yes, yes. Let the matter.
Not today, same position
Same
tomorrow.
Yeah.
42.
I'll pay for not to pass over.
Passover or not today. Make up your mind.
Not today.
Not today.
Keep it up.
43. 44. 45.
Item number 45, Lordship, Mr. Sachit Talukdar is appearing for the state. Lordship, he is out of station. Lordship would kindly make it not.
Sachin Tendulkar.
Mr. Sachit Talukdar, Lordship, he is out of station. If your Lordship would kindly make it not this week.
On the prayer made on behalf of the applicant, let the matter stand adjourned for the week. এই petitioner বলো বুঝেছো applicant বলো না petitioner.
Week 45. 46.
Lordship, item number 46, Lordship, similar prayer, Mr. Sachit Talukdar is appearing for
46.
Lordship, only one indulgence, Lordship. Item numbers 29 and 30. Your Lordship was pleased to make them not today. If your Lordship could kindly make them not this week, Mr. Talukdar is appearing for the state in item numbers 29 and 30.
Yes, sir, but the petitioner is not represented now. At that time, the petitioner's learned advocate was there. We will adjourn it, don't worry.
Lordship.
You should be here and you should remind us
Lordship.
when the matters are called on.
Lordship. Grateful, Lordship.
Forty-seven.
Respondent
You're opposing. Whom are you opposing? Nobody is proposing.
48.
Not today.
41 কি কোনো স্টেট ছিল? 48.
Same.
49. 50.
I am for the appellant petition.
Other side?
The lower court, Mr. Subi Sharnal appeared.
Are you aware of a resolution that?
Yes.
What do we do? Only not today.
Not today, and can it get little preference? There is little urgency.
No, this is the fourth matter under the heading application. The first three are all connected.
Okay.
So it will be taken up together.
We come back tomorrow.
51.
Proposer is also present, my lord. এত বড় চেয়ার আনি ধাক্কা দিলে পড়ে যাবো না?
Oppose.
No, I beg to propose.
And he can oppose himself. I don't have a problem.
All parties are here.
Lord,
See the statement.
Mr. Rise for the writ petitioner.
Doesn't matter, Mr. Chakraborty.
Mr. Galib is for the
Your
Waqf
resolution is there with us. Your request, unless all parties are there.
Parties are not there, man.
We will not touch
But,
it. Unnecessarily, we will not invite criticism.
Lord, it is only the Waqf board. Mr. Galib is here. খবর দিচ্ছি, Mr. Galib.
Unless all Passover, get all parties, we'll take it up.
Very well. But I am not proceeding with it. Let everyone come. The state is not there, my lord. Perhaps only the Waqf board and us. Both private parties are here.
The state is wrongly recorded, my lord.
Surajit da kothay?
Because the very cost title is defective. Because
There is no state, my lord.
only the WAP board. Cost title defective, no matter will be taken up. WAP board is the answering, and WAP board is a party also.
Kindly have a look at the cost title.
Defective, দাও না কোথায়
আমাদের আপিলে কস্ট টাইটেলে ভুল নেই, হ্যাঁ ভুল আছে, শুধু মেমো অফ অ্যাপিলটা দিন না কাইন্ডলি have a look at the memo of appeal block. Then I take your lordships to the other pages of the writ petition.
কি অবস্থা
State is not a party.
Like appear for the app with Mr.
You are the account board. You are the account board.
Lordship, I beg to
No, everything said and done. Kindly looks into the nature of the order. If this order is,
And you are Destiny and Sanjeev.
Yes. Yes, well, my destiny. Not respondent number 5, 6 and 7.
অনেকক্ষণ বলবে সবাই বলতে দি
2 to 6. Only 6. Oh, Daulat.
Seven হচ্ছে আষ্টফাইল মোতাবেলি, আমি প্রেজেন্ট মোতাবেলি।
সরে যাও
the respondent number 4 is the appellant.
কোন অর্ডারটা তাহলে order challenged has already been implemented.
The order challenge has already been implemented, that is recorded.
Sorry, Malik.
The orders challenged have already been implemented.
That is what they say, Malik. Yes.
That is recorded. And then the learned judge stays the order.
Malik,
without deciding the issue of maintainability.
Malik, she keeps it open and says that it is to be done on affidavits.
We don't approve of it, Mr. Roy. Not the right course of action. Even if prima facie, her leadership would have recorded, no, prima facie, this is maintainable. Because anyway, it's never alternative remedy is never a bar.
Absolutely, Malik.
Where violation of natural justice is alleged.
Yes, Malik.
There is at least one Supreme Court I am aware of, Justice Dipankar Datta, saying that
maintainability and entertainability.
In spite of existence of alternative remedy, if violation of natural justice is involved,
yes,
should take it up. The writ court should take it up.
Yes, Malik. Not only that, Malik, but also the propriety.
You tell us, has the order been implemented?
Malik, no, not in full.
Or in possession has been taken?
Malik, possession has been taken, Malik. First of all, Malik, today, Malik.
First of all, what are these two orders? That
Malik, may I
8 February and 30th July.
Yes, Malik, may I just, Malik. Malik, a proceeding is initiated. Proceeding is initiated, Malik, against my client. Who is my client? My client had entered into a development agreement with the Waqf.
for the purpose of developing the property and my lord, giving out to tenants. Now, my lord, tenants have got their property and suddenly after possession, one of the tenant complains to the Waqf board saying that I have not been given my entire area. That is what the tenant complains. Now, suddenly the Waqf, the Mutwali, though he wasn't the Mutwali then, but he subsequently made a Mutwali, he comes up and now starts saying that yes, that is correct. Entirety has not been given. Now, pending this development agreement, my lord, my client had taken over a tenancy in that property itself from another third party, which is allowed under the law. Now I am there. I have given possession. Now suddenly this complaint comes. The Waqf board on its own passes an order. I will come to the violation analysis later. May I just point out what has happened in the meantime? Because I have not been even given the documents on the face of it. Now, the Waqf board says that give back possession of what? The tenanted part, which I had taken over as a tenancy. And
one second. Sorry, Mr. Bhattacharya, your contention is that you have taken possession.
Yes.
So
my lord, apart from that, this or whatever my learned friend says, my lord, he has the right of audience before the tribunal. There is, and not only, my lord, it's not a question of efficacious remedy. There is an existence of a tribunal before whom this matter has to be carried from this 30th July order. Irrespective of anything, whatever points he has, even if he has, according to him, not been heard properly, he has to raise that point before the tribunal. There is a specific section 83 of the Waqf Act.
Malad, I would like to make submissions on that when your lordship permits, Malad. That may not be sacrosanct as such, Malad. And I will also refer to recent judgment in Waqf.
Matter is pending before the learned judge. Go back, whatever the status is today, maintain that status, all parties.
That is being maintained, Malad.
Do that. Status quo as of date shall be maintained.
It is already
whatever
there.
The status is. If you have taken position, you have taken position.
Whatever it is, if I can get orders, I'll get orders.
Whatever status is there today will be maintained. Let the learned judge decide it. Why should we go into all these?
Now, please see.
Nature, character, possession, whatever.
Lord, if the restriction is on the face of it not maintainable, Lord, kindly do not, with greatest of respect, Lord, kindly do not relegate the matter. And Lord, kindly do not relegate the matter back to the Honorable Single Judge.
We will relegate with a request to decide the question of maintainability as a preliminary point.
Alternatively, what I was humbly suggesting to your lordship, subject to what falls from your lordship, looking at his pleadings in the writ petition, starting from paragraph 27 onwards, what I was respectfully submitting to your lordship, subject to what falls from your lordship. This entire issue has to be agitated before a competent forum.
Make that submission before the learned single judge.
Please see paragraph 27.
We will not go into it, Mr. You are protected. Status quo as of date is maintained. Let the learned judge decide all issues, including
that lodging of FIR part, has to be, kindly sees the nature of the order. If the Honorable Single Judge writes, paragraph 4 of the impugned order.
What will I have?
Is also directed to start criminal proceedings against the petitioner, apprehending the same, the writ petition has been preferred. This portion of the order, apart from anything else, kindly do not prevent us from proceeding as per law.
Have we told you we are preventing?
If that is understood.
Why, I don't know. Have we even indicated?
No. The criminal part was never indicated.
That much stay I must, I have got from the single judge, kindly appreciate that much. To the extent that criminal proceedings will not be started.
No. That is not the...
Completely without jurisdiction.
Issue.
Criminal proceedings have not been initiated as such,
No.
Kindly appreciate the order was, that they will initiate. And that too, if I cannot pay back, that is the point, Kindly cease their conduct now. They are wanting to initiate criminal proceedings.
Why will I not?
Why will you? How can you?
Why will I not?
Well, it is without jurisdiction. Well, may I just kindly argue this much?
Without jurisdiction, whose order?
Walk-up order.
Waqf board order without jurisdiction.
Completely without jurisdiction.
Whose jurisdiction is it?
But kindly, if your lordship is not minded on that, it kindly allows me to make submissions. I'll be coerced, completely coerced.
দেখাচ্ছি বাবা দাম। হ্যাঁ এখানে ফার্স্টেই তো আছে, প্রথমেই আছে, এইখানেই আছে, এই তো 30th জুলাই, page 107, 30th June, नहीं तो 131, 107 to 131, subject to collection by you. I don't know.
What is the charge against criminal charge? What is the proposed criminal charge against him?
No criminal charge, may I show that?
Criminal, why this directive?
It says that I have not taken, I've not paid the rent. If I don't pay the rent, criminal charges for misappropriation.
Now, please see page 156.
So it is not a criminal, there is not an offense committed by you.
There is a clear case of cheating.
No, there is no clear case of cheating.
How?
I was in possession. They had given me possession. I was the joint developer with the
Mutwali. An offense of cheating. If not paying rent is not.
Now, please see page 153 onwards.
153 onwards, finding and the order of the trial.
Waqf board not right.
Maybe other allegations.
I will not get
Now, please see page 153, paragraph 1 onwards.
Mr. Roy, while we may interfere to the extent that there's direction to initiate criminal proceeding will not be given effect to, but if otherwise the respondent number 4 in the writ petition has a cause of action, we can't stop that.
I only want stay of that part which directs on that basis.
Direction we might interfere with, but that will not prevent you otherwise.
Section 41 specific relief act, there cannot be an sanction on criminal action.
What order have I got?
That's what
I can only stay of that part of the order.
A direction will not be effective, but that will not stop you. Yes.
Yes, it cannot be pursuant to
That
this
liberty
order.
is always there.
Clarify that.
Kindly clarify.
Not pursuant to this order, madam. That is what I want.
What? It is independent of any order.
I only say this much, my lord. This
The direction is going all right.
And if they want to, let them take whatever steps they will want to take against me, if they have the authority.
A judgment and order dated October 14, 2025, passed by a learned judge of our court in WPA 22210 of 2025, being a writ petition filed by the respondent numbers 1 and 2 herein, comma, is the subject matter of challenge in this appeal at the instance of the respondent number 4 in the writ petition. Paragraph. It appears that the respondent numbers 1 and 2 herein, comma, who had some property dealing with the appellant Waqf board. Is it Waqf or Waqf? Waqf board.
Awqaf lordship.
Awqaf. AUQAF.
No, he's His agreement was with the Matwali, vetted by the board.
Vetted by the
board. His agreement is with the Matwali of the Waqf estate, vetted by the board.
The
NOC is given by the
one
board.
and two hearing with the Mutwali of the appellant Waqf board, which was vetted by the board. Stop. Certain disputes having arisen in respect of such arrangement, comma, the respondent numbers 1 and 2 herein approach the learned single judge. Stop. Paragraph, before the learned judge, a point was taken on behalf of the present appellant that the writ petition is not maintainable since the order sought to be challenged in the writ petition. Want to go? Acha, কি বললাম? আবার পড়ো. Before the learned single judge. Present appellant as well as the respondent number 5 in the writ petition. তারপরে কি বললেন? Since the orders challenged in the writ petition were appealable orders under section 83 of the
Under section 83, subsection section
95.
section 83 of the Waqf Act.
How na?
This is another part.
83 subsection 2. ওটা সিভিল কোড বা ছাড়ো না 83 subsection 2. Any person agreed by the order.
83 of the Waqf Act, 1995. Stop. The learned judge passed the impugned order, the relevant portion whereof reads as follows. Paragraph 3 থেকে
No.
11 অব্দি একদম সেট আউট করুন।
Kindly pardon me. Please see page 159 once. Only once and thereafter, just pass the order.
Volume 1.
159
That was
or
volume 1.
your lordship may look into
Then when kindly hears me also, my lord.
Volume 1.
volume 1.
Why have we told you what order we are going to pass this?
Only this much. What action was contemplated? Just nothing else. Just for your lordship's page 131
Off.
or 159, whatever.
Without hearing me, without giving me documents.
Volume 1, 131.
Wants us to see our order is not going to change.
Wait. Just one. I may read it for your lordship.
Yeah, give it to your lordship, my lord. It's open if your lordship wants.
Yes.
It will be marked as an exhibit then.
I don't mind, my lord. It will be my pleasure, my lord.
159.
Volume 2.
Please see direction number 8. Nothing else.
Capturing 5,000.
This is my hint.
Very well noticed.
That
কি বললাম? Set out. Paragraph, being aggrieved, the Waqf board has come up by way of this appeal. Paragraph.
Board ekdom very much in accordance.
We are of the no. Since the writ petition is pending before the learned single judge, we are not inclined to go into the merits of this case. Stop. The learned judge is yet to finally decide the disputes between the parties. Paragraph. The point of maintainability of the writ petition shall be decided. Now, get it up. We request the learned single judge to decide the issue of maintainability of the writ petition as a preliminary issue before addressing the merits of the case. Stop. insofar as the direction of the, this is a direction by the Mutwali,
Board of Workers.
Board of Waqf to the Mutwalis. To the Mutwali,
to the chief
executive officer.
And Mutwali, both.
To the chief executive officer and Mutwalis of the board to initiate criminal action against the writ petitioners.
Yes.
Against the writ petitioners is concerned, comma, we only clarify that stay of operation of such order granted by the learned single judge shall not stand in the way of the Waqf board initiating criminal action against the writ petitioners if they are otherwise entitled to do so in law.
Waqf board and or Waqf estate.
Today, the Waqf board has passed an order.
Waqf estate only represent
So
Matwali
Waqf board
hai.
has not, it has passed an order directing someone to lodge an FIR.
We are saying
CEO and Mutawali, CEO is of the Waqf board.
And the Mutawali has taken possession, which it could not, because under the Act, Mutawali cannot take possession.
Manipulating and misleading the board as well as Mutwali for doing fraud. Chief executive officer.
Well, that is what I'm challenging without
direction
hearing the Waqf board.
of the chief executive officer, brother. And Mutwalis bolechi na, kari chief executive officer.
Waqf estate includes Matwali, no problem. With the bull and on the Waqf estate.
Paragraph. With the aforesaid modification and clarification, comma, we dispose of the appeal and the connected application, stop. We have not entered into the merits of the case, stop. All points are left open to be decided by the learned single judge in accordance with law and as expeditiously as the business of the court may permit.
Status quo, your lordship said, my lord, whatever the status.
Till the learned
as it exists today.
Till the learned single judge decides the writ petition, comma, let status quo as regards nature, comma, character and possession of the property in question as of date, status quo as of date be maintained.
41 pages in the place full length. Additional document.
If my seniors leave, we shall use the affidavit within a week. The opposition itself.
You're out of time already. Direction was given.
What in the time? Sir, use it within a week. Let them use it within another week, Lord, so that we can approach the LRC.
1 week, 1 week.
1 week, my lord.
Only one thing,
না না একটু সময় দাও আমাদের ইউজ করতে হবে
Nature character কেটে দাও খালি possession.
My kindly give me 2 weeks lordship. Board will also have to use opposition.
Only there is another connected application seeking to, my lord, introduce certain documents. We'll introduce them in the affidavit. Kindly dispose of that application. That is can number 1.
Order for Rule 27 application.
Before us.
Yes.
We filed an order for
We are
Rule
disposing
27.
An abundant precaution.
We are disposing of
Disposing
everything.
of all applications. And
Yes, appeal and all connected applications. You wanted to say
The
something.
allegations in
the allegations in the writ petition are also not accepted.
Possession করে দিয়েছো, nature character কেটে দিয়েছো.
You have asked me to present it.
Allegations made therein are not accepted.
Yes. The respondents will be at liberty to file their affidavits in opposition before the learned single judge within a week from date.
No, I kindly make it 2 weeks because board will also have to use opposition, because it is post resolution and a challenge.
2 weeks from date, stop. Reply thereto, comma, if any be filed within a week thereafter.
One makes it 2 weeks. There will be so many parties giving us opposition.
2 weeks thereafter. একই তো দাঁড়ালো কি, stop.
একই তো হলো তাহলে। উল্টা আগের টাইম
The parties will be at liberty to mention the matter before the learned single judge for hearing of the matter after exchange of affidavits. Stop. Paragraph. Since we are disposing of the stay application without inviting affidavits, comma, the allegations made therein are deemed not to be admitted by the respondents in this appeal.
The application and order 41 rule 27.
Since we are disposing of the stay application and the application
For additional.
under order 41 rule 27 of the Code of Civil
That is not the
Procedure,
nomenclature.
comma, without inviting affidavits,
Can I
comma, the allegations made in the said two applications are deemed not to be admitted by the respondents in this appeal.
One small step. And your lordship's direction, which your lordship is just confirmed with status quo, whichever, whatever. But your lordship is directing that the board will be entitled to take criminal action
If they are entitled to in law.
if they are entitled in law.
That is there.
And but the stay which your lordship is, well, the stay to that extent of paragraph 8 may be granted.
Modified. No. Order is modified.
Kindly appreciates the stay with regard to paragraph 8. Because, my lord, your lordship, I have said that I have not been served, I have not been heard.
Mr. Roy, please understand.
My lord,
You have obtained a stay of that direction.
yes. Stay of the entire direction.
We have not interfered with that.
Makes that
We have only clarified that the stay shall not stand in their way
if they are entitled to in,
if they are entitled.
I'm sorry, my lord, because this is basically a pressure tactic is going on, my lord. So, my lord, I need to know that.
Chalo. Jao.
Lord, perhaps in the earlier part of the order, my lord has recorded the appeal is by the board, the appeal is by the Mutawali. Perhaps in the first
New
portion of the
Mutawali
order,
Milord, respondent number 4 in the
perhaps that has
petition.
gone at the beginning of the order, my lord. If kindly pardon me if I have heard it wrong, my lord.
You own only Matawali, the sole Matawali.
The Mutawali has filed the appeal.
Is the Waqf estate represented through the
Yes, by a Mutawali.
Perhaps what I have heard, my lord, is that the board has filed that.
Oh, appeal to board by Waqf estate.
Yes, only that, only that.
Estate. Board, we should appeal to Waqf estate for Waqf board এর না। ঠিক আছে?
ওই জায়গাটা বলো সিওর সঙ্গে
WAF board and or WAF estate.
Waqf.
The words have been used.
আর কি বলবো কি বলবো রে ভাই এগুলো বলিস না এগুলো ডিসেম্বরের মধ্যে বললেও কি হবে নাকি বলতে নেই সব গ্রেটফুল ডেভেলপ
But I appear for the appellant. I am appearing for the respondent writ petitioner. My lord, I do not know whether appearing is not. But the matter was mentioned by my learned junior.
All very well, the resolution is yours, Mr. Kaur.
Lord, that's true.
But we are not going to unnecessarily invite any kind of controversy or criticism.
So my suggestion is something else. I was suggesting, Lord, if today your lordships can't take it up, tomorrow, Lord, if it has some precedence.
একটা কাজ করো না কালকে বেলের আগে এই গ্রুপটাকে তুলে দাও বেলের আগে তাহলেই হয়ে যাবে ওর বাবা
Much obliged.
There is one difficulty, my lord. All the pleadings are not before your lordship. I reply the opposition filed by state. So I will request my advocate on record.
The stay. I don't need those
I think
documents.
those are required, my
Only
lord.
document required
The
is
state is the answering respondent. They filed a opposition.
You bring copies?
My lord, I can, my lord, produce those records.
Produce copies?
Yes.
If necessary, if you want to rely on them, produce.
My lord, instead of tomorrow, my lord, kindly fix it day after.
Lord, problem is my tender has been cancelled by the learned trial judge. And Lord, any day I've been asked to continue till a new process is selected. Lord, any day I'll be, Lord, asked to leave.
The learned single
Before
judge also protected
the private respondent, my lord, to the extent that he will allow, my lord, he will continue for the next 4 weeks from 27th. No, but then 4 weeks, within that 4 weeks, is the process is complete, I'll be asked to go.
Kindly fix it on Wednesday.
In fact, it happened yesterday. Yesterday, they were asked to leave. And just because the appeal is pending, we ask for a 8 days time.
Not today, chal.
কি প্রবলেম আছে কিছু পার্সোনাল প্রবলেম আছে 53 যদি হয়ে থাকে বলিস না মাছো
Which one?
Item 15, the criminal appeal hearing, my lord.
Criminal appeal. So the appellant is not here, what to do?
54, 55.
I'm for the appellant, my lord.
Unless both sides are there, we can't take it up, sir.
Just one indulgence, lordship. There is an application for bail pending, suspension of sentence. So this has come up under the heading hearing of.
But that application is not in the list.
It shows up as CRAN 2, my lord.
Item 55.
54.
Oh, 54. হ্যাঁ, CRAN 2. তাহলে ভাই কেন এটাই heading এ আসছে? It will be listed under the appropriate heading, bail in connection with appeal. Tomorrow itself, it will be so listed. Have you served on the state?
Yes.
Bail application?
Yes, yes. Everything, the service is
under which section you have been convicted?
302, my lord.
372.
302.
Please note, item 54, state has been served. Somebody should appear for the state. Suspension of sentence. বাবু, তুমি বুঝতে পারছো?
Milord, I am for the appellant. Milord, Milord, one thing I am praying, Milord, I am not collected the paper book. Milord, it was prepared. Milord, I'll take and come on Friday, Milord.
On the request made by learned advocate for the appellant, Rupa Sardar, what has she done?
Milord, I am Milord, against the order of acquittal. Milord.
Oh, I see. You are the de facto.
My lord.
Appellant, for the appellant, comma. Let this matter stand adjourned and be listed again on Friday, date the other.
My lord.
56.
My lord, I am for the state, my lord. Lord, can this matter be kept for Monday, my lord? Because
the appellant is not represented. Stop. No adverse order. Resolution.
Oh, but I'm just.
Not today. That is an adverse order.
My lord, I'll come back.
Tomorrow come and pray for time, no problem.
57, 58.
My lord, I have got the appellant, my lord. My lord, I have received the paper book, my lord. Matter was about to, my lord, move before the, my lord, the previous bench, my lord. I was directed for preparation of the written notes. That is also ready. Mr. Basu is for the rest of the appellant, my lord. Shekhar Basu. So, my lord,
the appellants,
4 appellants.
I see. Different lawyers for different appellants.
My lord, my lord.
I doubt if that's permissible. Anyway, what do you want?
As your lordship may please, my lord, I am ready to move this matter, but state is not here at no advance, my lord. Tomorrow, my lord.
Not today.
Be pleased, my lord.
Not today.
59.
My lord, I am for the appellant. My lord, I am praying for not this week.
On the request made by learned advocate for the appellant, let this matter stand adjourned for the week.
Week.
What is this CRAN, sir? There's a CRAN. There's a CRAN application in your matter.
Yes, my lord.
What application is that?
My lord, my son.
What is he has obtained adjournment for the week. What is this CRAN application? তোমার রাখো না ফাইলে আছে কিনা।
CRAN has already been disposed of. If I'm not,
Disposed of.
yes, there was a delay period. There's
যেন না আসে বলে দিও।
that was,
কেটে দাও।
my lord, only one thing. What I find that these are appeal against acquittal. We have served the accused persons, but despite our service, one of the accused person could not be served, despite it has returned. So, my lord, to my humble estimate, subject to your lordship's acceptance, if this person can be served through state.
Why state? State is not there today. State is not there today. We pass that order, no problem.
Then, my lord, keep it on tomorrow,
Not,
and my lord, then this order will be
এটা করো না। ওই অর্ডারটা কেটে দাও, not today, খালি not.
most of it.
রাখুন 60 and 61.
নেই
62, 53.
Lordship, 63, this is an appeal against the order of acquittal. Lordship, at present, my client does not wish to proceed with this appeal. So, Lordship, I about to collect the letter from my client. Lordship, kindly give me 1 week time so that I can collect the letter.
On the request made on behalf of the appellant, let this matter stand adjourned and be listed again next Monday date thou under the heading to be mentioned.
Yes.
54, 60, 65.
I'm led by Mr. Shomi Ganguly. On his ground, I'm prayed for not this week or some next Monday.
On the request made by learned advocate for the appellant, let this is an appeal against acquittal.
Not even.
Appellant, let this matter stand adjourned for the week.
65. 65.
Obliged.
66. 67. 68. 69.
69, your lordship. Mr. Niradi Sekhar Ghosh is leading in this matter, your lordship. If your lordship kindly fix it on Wednesday, we are ready. On the last occasion, your lordship directed the state to appear. They did not appear, your lordship. I will inform Mr. Rudradipto Nundi, your lordship. I had a talk with him in the morning, your lordship. Kindly fix it on Wednesday.
Wednesday, order করতে হবে।
Madam.
70, 71 to 73, 74, 75, 76. Thirty-seven constituent.
Staff has been useful. Staff
37 is the password. Item 37.
The appellant. See, on request, I have requested to the Mr. State respondent. He is appearing. His name on Shina. So I am requesting to appear in this matter. So now he is not appearing.
Is appearing, item number 37.
Who is appearing?
So Shur is appearing, Lordship, in item number 37.
Are you appearing in item number 37?
Yes, Lordship, I am appearing on behalf of my senior.
The microphone.
Lordship.
You are appearing on behalf of your senior.
Yes, Lord. So, Lordship, just on the
at the time of calling lordship, just no one appearing on behalf of the state. So lordship directed to my senior that call to the state authority, but we have called state authority, but no one responded on the other side. So that's the lordship I am praying for not lordship.
Not today.
Yes.
এত কথা ঘুরে গঙ্গা not today. চলো চলো এসছে কৌশিক। হ্যাঁ
থাকো না,
রাখো রাখো।
এসছে তো এখানে।
লেখা আছে। তুমি লিস্টটা পড়েছো? লিস্টের নোটটা পড়েছো?
Oh, yes, sir. Yep.
শুধুই
174202. For your side matter, item number 1.
Before your lordship's original side list is called on, your lordship, may I have your lordship kindly leave to mention a matter for correction of the order, your lordship. Your lordship, your lordship, the order was passed by the previous bench, your lordship, taking of the appeals, APOTs, your lordship. Your lordship, Honorable Justice Devanshu Basak and Honorable Justice Mohammad Shabbar Rasdi, your lordship. Lordship has a determination now.
No, correction, their lordship's order. If you today ask for recalling of that order, where will you go?
Let's, but the bench is not comprising of the same forum, your lordship.
Sir, what their lordships meant, how will we know?
Lordship, my matter was dismissed for default, your lordship. The case number has gone wrongly there. Instead of APOT, your lordship, APO has been written. That is why I issue. Your lordship, may kindly just see the order. The case status also I am handing over, your lordship. It would be APOT, your lordship, and the APO has gone down in the order. That is the sole.
শুধু নাম্বারটা কারেকশন করবে বলছি। এখন তো আমাদের এসে গেল, আমাদের
APOT-তে 3টা পয়েন্ট।
এপিওটে
Much obliged, your lordship.
Item number 2.
Mr. Simongal Singh is appearing on behalf of the respondent bank. He is ill. I prefer not to. I prefer adjournment no one.
Item number 1. 2. Item number 3.
May it please your lordships. Because I'm led by learned senior advocate Mr. J.P. Khaitan in this matter. My lord, Inox. Inox Air Products. My lord. There was an order of the Honorable Division Bench dated 4th October 2023 for tagging of another appeal which arises from the same impugned order. My lord, for tagging.
Sir, I'm paying for the respondents in this matter.
That is not appearing in the list.
No, my lord. It would be APOT 255 of 2023.
My lord, the Honorable Division Bench has directed both these appeals to be tagged together, my lord.
And to be heard analogously.
And heard analogously.
Tag করে দাও.
My lord, if my lord desires, if the appeals can be fixed after 20th, any date subject to my lord's kind consideration.
20 তারিখের পর দেবে.
May I be permitted to record my learned senior's presence, my lord?
দাও এটা দাও রেকর্ড করো একটা. By an order dated October 4, 2023, a coordinate bench had directed that the present appeal and APOT 255 of 2023 be tagged and taken up together. Stop. Let that be done. Stop. List the two appeals under the appropriate heading.
27th.
On
27th, subject to my lord's kind considerations, my lord.
November 27, 2025.
Keep you obliged.
27 November.
Give the appearance.
So very grateful.
27, eh?
Great.
Hello.
Item number 4. Password. Item number 5.
Please, this is the matter Mr. Jishnu Shah had mentioned last week. Well, because of some urgency. But without taking your lordship through the papers, this is an appeal against an order passed in a writ petition filed by the appellants.
All parties are here?
Yes, all the parties are here. All the parties are here.
And I'm for the resolution, the corporate debtor resolution
Prasad
professional.
is for the state authorities, MSME authorities.
You are for?
My lord, I'm for the corporate debtor to the resolution professional, my lord.
My lord, I am for the successful resolution applicant.
My lord, he's for respondent number 3. My learned friend is for respondent number 2, and Mr. Prasad is for respondent number 1. I'll just indicate what is the urgency. Just a brief backdrop.
No. But how will it serve your purpose just to indicate what the urgency?
No. I'll take your lordship. I'll utilize the time that I have till 3:30. I think I'll just take 5 minutes to explain the matter. It's perhaps take your lordship to the paper. And I'm praying for certain urgent interim orders. I'll tell your lordship the reason is. Respondent number 3 company is a company which is undergoing corporate insolvency resolution process before the National Company Law Tribunal. Lordship knows once.
What is the name of the respondent?
It's by the name of respondent number 2 company, Jagadamba Industries Limited. We are concerned with this company by the name of Jagadamba Industries Limited. The Section 7 was filed by a financial institution for a default committed in excess of 300 odd crores. Corporate insolvency resolution process was initiated before the National Company Law Tribunal. Your lordship knows once the corporate insolvency resolution process is initiated, an officer by the name of resolution professional gets appointed in respect of the company. That is appointed by the National Company Law Tribunal. And in that process, the resolution professional prepares something like a mother document called an information memorandum. That is the mother document of the company on the basis of which resolution plans are invited for in respect of the company, the corporate debtor undergoing corporate insolvency resolution process. Now, my lord, I am the appellant before your lordships is one of the resolution applicant in respect of the corporate debtor. When I gave the resolution plan, respondent number 3 also gave a resolution plan. Now, my lord, what happened in the information memorandum? there was nowhere mentioned that the corporate debtor, that is the respondent number 2 company Jagodamba, is a MSME entity. Because it is relevant, because my lordship knows under the insolvency and bankruptcy code right now, related parties of the corporate debtor of the company which is undergoing CIRP, insolvency, will not be able to give resolution plan in respect of that. So what you can't do that directly, you cannot do that indirectly. That was the purpose which section 29 capital A was enacted. The defense to section 29 capital A under the code is 29A is not attracted, the related party thing is not attracted if the corporate debtor is an MSME. So Malad, what happened was respondent number 3 entity, Jagodamba's promoters. Malad, respondent number 3 is basically Malad, the promoter of respondent number 3 is the son-in-law of the promoter of the respondent number 2 company, which is undergoing insolvency. So clearly hit by the related party status. So Malad, when we challenge the resolution plan, all of a sudden, the resolution professional says that the corporate debtor is an MSME. And Malad, 2 dates are important. Malad, corporate insolvency resolution process gets initiated on 22nd August 2023. And an MSME certificate is produced, or rather is obtained on 25th August 2023, which is after the CIRP initiation of the corporate debtor. And Malad, I'm sorry, Malad, I'm led by Mr. Shah. Malad,
But, may I start from the beginning? I'm told it's a very good place to start. So, my lord, 2 things, 2 provisions your lordship will kindly have a look at, my lord, at the outset. My lord, IBC, my lord, section 29A. I need not trouble your lordship in great details, but 29A in essence says, my lord, if you are a related party of the corporate debtor company which is undergoing insolvency resolution, then you cannot put in a resolution plan. You cannot apply to be a resolution applicant. Now, that bar was relaxed subsequently by an amendment by section 240A, which says, however, this bar of a related party will not apply if the corporate debtor is an MSME entity. Whatever the statutory or legislative scheme or mandate is, so this bar of a related party entity is relaxed for MSME entities. I will not trouble your lordships to show as to how they are related parties. That is a matter which I can agitate before the NCLT, which I have already done. The question which has been returned to me by the NCLT is that, look, how will it make a difference? You say that they are related parties. How will it make a difference if the corporate debtor entity is MSME? Because in that case, naturally, you will be absolved of, they will be absolved at that bar. So, the question, really, that it ultimately boils down to is whether the corporate debtor company was MSME or not.
As on the date of initiation of the process.
No.
Of
here, interestingly, although that was initially the view, that are you MSME on the date of initiation of the corporate insolvency resolution process? Now, there's a Supreme Court judgment, which says that the question would be whether you're MSME on the date on which you submit the resolution plan or make the resolution application. So, here, of course, there are contrary judgments, but this is the one of the views that is expressed. So, I shall proceed presently on the premise that
isn't this pending before a larger bench, this issue?
No.
Larger bench of the Supreme Court?
Total. What do you mean total?
No, not anymore. Central bank matter.
Yeah.
After that.
The question, as to what is the date, relevant date? That is a decision rendered in a case called Haribabu Thota. I am told that that is not under review or reconsideration. But there was subsequently a judgment which the Supreme Court said that the writ court can go into the question, and that is the basis on which we come.
Writ court can?
Yes. I should show your lordship the judgments, but may I just give your lordship the background? Now, when today, there are 2 resolution applications who participate. I am, let me call myself the unsuccessful resolution applicant. Although I say that I was never entitled to be declared unsuccessful because I was the only eligible applicant, only non-related party applicant. So, my lord, when ultimately the committee of creditors proceeded to, my lord, approve the plan of the respondent number 3, I came up, my lord, before the resolution professional and said that no, you couldn't have done that. You couldn't have ultimately put up this case for consideration before the committee of creditors because the other party is a related party.
Wouldn't this order with which you are unhappy be appealable before the appellate tribunal?
No, my lord, because here, my lord, this, my lord, question as to whether MSME, my lord, the corporate is an MSME entity or not is, my lord, not within the domain or purview of consideration of the NCLT at all. My lord, in fact, my lord, these are, my lord, questions with which they can't concern themselves. Of course, my lord, the question to section 29A, are you a related party or are you not a related party? That is clearly a matter covered by the Insolvency Bankruptcy Code. So that can be considered. But are you MSME or not MSME? On the date of, my lord, submission of the resolution application of the resolution plan, that is, my lord, not within their domain or purview. So, my lord, I would have no, my lord, access to, my lord, an appellate tribunal. And, my lord, I understand that this is now, my lord, settled position of law, that, my lord, the MSME, the NCLT or the appellate tribunal cannot go into this question. The question of validity of an MSME registration is not within, my lord, the purview of the tribunal. Now, my lord, here, just to give your lordship a brief background of what happened, is, my lord, when the resolution professional was approached, my lord, with a challenge that no, this is a related party, you could not have ultimately put up his plan for approval before the committee of creditors. He, my lord, writes back saying that no, but he is also MSME for the first time. Well, then, my lord, starts the process of inquiry. In the process of inquiry, I'll take your lordship through the relevant documents. It is found that, my lord, the electricity supply had been cut off. My lord, there was no manufacturing happening. There were no production. There was no employees. No plant and machinery. It was, my lord, in a completely junked condition. Now, my lord, today, if that be the position, then, my lord, MSME is ultimately to facilitate, my lord, small industries, which ultimately subscribe to, my lord, the financial requirements of MSME industries. They are small, medium, and large. But, my lord, if an industry is not functioning at all, if it is not employing workmen, if it is not producing, if it is not manufacturing, if it is not generating revenue, then it cannot be accorded the MSME status. And, my lord, what happens is, my lord, for the purpose of MSME status, my lord, what happens is after the period for which, my lord, the certificate is granted, it is not for ad infinitum. It is limited by time. You have to seek renewal of the certification by making a self-declaration. Now, my lord, now it is on the basis of the self-declaration that new certificates, new registrations are granted. But there is, my lord, a government notification which says that if it is found that you have made a fraudulent or false self-declaration, then that is a ground for cancellation of your registration. Now, my lord, here, my lord, this is the, my lord, background of the matter in which, my lord, we have approached the court. Now, well, I must tell you, lordship, that the learned first court on our application is ultimately satisfied that as on the date of commencement of CIRP, that is the impugned order, you did not have requisite MSME registration. But, my lord, the first court stopped short of inquiring into as to, my lord, whether you had MSME registration on the date when you submitted the plan. Now, my lord, today, having won, I would really say that I have won and come up in appeal because, my lord, I have only won half a victory. It's a Pyrrhic victory. So, my lord, here I am before your lordships, my lord, because the learned first court has, even while holding that, my lord, the corporate data company was not an MSME on the date of commencement of CIRP, ultimately did not really go to, my lord, adjudicate on the question or decide on the question, even, my lord, without an inquiry into detailed facts, because, my lord, it's all on record. As to, my lord, whether today on the date of commencement on the submission of the resolution plan, it was, my lord, an MSME entity. My lord, please see, my lord, the impugned order once straight away before I, my lord, take your lordship to anything else. The impugned order.
So we have seen the impugned order. What you were challenging before the learned single judge was order of the RP.
No, my lord, what we said is, my lord, here, my lord, we had applied to the MSME authorities to cancel the registration because they had obtained, my lord, a registration on a false declaration.
I see.
And, my lord, here, initially, my lord, the reports are returned by the MSME authorities saying that, yes, your registration should be cancelled. But then, my lord, if your lordship looks into the records, your lordship will find that, my lord, different MSME registrations with different dates and different particulars of surfacing. Now, my lord, today, my lord, the entire process of corporate insolvency resolution, my lord, is, my lord, a matter of, my lord, very high stakes. Let's put it that way. So, my lord, one has to inquire into, my lord, whether the MSME authorities have, in the course of, my lord, ultimately subscribing, my lord, their hand to, my lord, the genuineness of the certificate, has, my lord, acted wrongfully or arbitrarily on the face of it. My lord, here, my lord, if your lordship sees, my lord, this was the initial response of the MSME authorities at page 453, if your lordship sees. My lord, this is at volume 4 of the stay application. I'll just show your lordship what was their approach. Why, my lord, we come up and, my lord, we agitate this issue before your lordships. Well, just, my lord, to give your lordship a flavor of, my lord, what we are now talking about, page 453. This is, my lord, when we initially made a complaint. Well, lord, this is what, my lord, the inspection report of the MSME authorities, my lord, ultimately held up. Yeah, after inspection, right? Well, lord, please see, my lord, this is the MSME Development Facilitation Office.
Mr. Shah, let's understand that we are hearing out the appeal itself.
Yes, yes.
All papers are before us.
Right, all papers,
Yes. I had a preliminary objection for that, but your lordship both take it. They just comes out the matter.
Maintainability of the appeal,
Maintainability of the writ petition.
writ petition.
Because they have filed, can you see page 644? They have filed for the same relief or substantially the same relief before the NCLT.
No.
For the writ petition, see the prayer, 644. And that has been for interim order, so they filed a writ petition and now it's reserved for judgment. Volume 5, no? Volume 5, page 644. This is the only on the maintainability. I will not go into the merits I shall separate. After this, whether they can maintain the they could at all proceed. 644.
Can I confer jurisdiction on a tribunal which does not have jurisdiction?
Prayer II. Prayer II. Exactly the same. Order be passed restraining, directing respondent number 1 out of the corporate debtor or the committee of creditors and or the respondent number 5 from as me, RP, COC, from placing any reliance on the purported MSME registration 25th of August 2020.
That's not seeking cancellation of the MSME registration.
So,
I have said that, my lord, you do not rely on it because we have challenged it in writ. That is, my lord, my learned friend's objection. I would have thought this was better.
644.
644. Roman II, the prayer.
II.
That is the application which they filed. That is CN, the IS 624/2025.
Well, that is
basically MSME can't be looked into.
That is because the writ petition is pending at the time. I have not asked for cancellation before the NCLT. I cannot. The NCLAT has ruled that you cannot. The NCLT does not have jurisdiction in this regard.
Petition was not pending then. No. Writ petition was filed on was filed on 9th June, present petition, and that's filed on 16th April. Anyway.
My lord, may I proceed with the matter? I shall not deal with my learned friend's arguments in course of things. Well, if your lordship, my lord, were to, my lord, once look at, my lord, the document to which I was drawing your lordship's attention, page 453. Well, that is at volume 4.
No, but Mr. Shah, that goes to the root of the matter.
Yes, my lord, may I start from the, as I said, my lord, let's start from the very beginning.
If you have asked for the same relief before the NCLT, which is pending adjudication, why should you be permitted to maintain a petition?
My lord, I'll tell you, lordship. My lord, let us, my lord, without my lord admitting any of that, I should show you, lordship, the context. My learned friend has shown your lordship only the prayers. I shall show you, lordship, the context. Now, my lord, so far as this is concerned, my lord, there is, my lord, authoritative rulings of my lord superior forums today which says that the NCLT cannot decide on the question as to whether the MSME registrations are valid or not. My lord, I shall just give your lordship the judgment immediately. My lord, I cannot by, my lord, consent confer jurisdiction on a court or tribunal which does not have jurisdiction. Well, this is the case of Ramesh Shah versus Central Bank of India. Well, this is of the NCLAT. This is the appellate authority.
You don't have any Supreme Court on this.
Yes, this thing.
Why are you showing NCLAT then?
Well, I'll show you, Lordship, the Central Bank one. Supreme
Show
Court is also
something which is binding on us.
Well, NCLAT, my lord, is the appellate authority of NCLT. So, my lord, as to whether, my lord, NCLT has jurisdiction or not, well, under section 61 of the Insolvency Bankruptcy Code, the only authority to decide on the question, as a matter of statutory appeal, is, my lord, the NCLT. And, my lord, that is binding on the NCLT. So, my lord, if today that is binding on the NCLT, then that is binding. And this apart, my lord, here, if your lordship also sees, my lord, since your lordship is asked about the Supreme Court, may I also show your lordship the order of Central Bank of India? My lord, please have a look at, my lord, 2025 SCC Online SC 440.
2025. 2025 basis.
2025 ACC online
440.
Yeah. Well, the writ court can consider this question, and that is, my lord, what has been directed by the Supreme Court. Now, my lord, here, if your lordship sees, my lord, paragraph 2, my lord, paragraph 1, my lord, this was section 9 proceeding by an operational creditor for commencement of insolvency. Petition under section 9 of the Insolvency Bankruptcy Code filed against the corporate debtor such and such was admitted by the adjudicating authority on 14 February 2020. A resolution professional was also appointed. During the pendency of the aforesaid proceedings, it is apparent that the resolution professional instructed an employee of the corporate debtor to make an application for registration of the corporate debtor as a micro, small or medium enterprise under the Micro, Small and Medium Enterprises Development Act of 2006 in terms of Gazette notification such and such. It is the case of the appellant Central Bank of India that it objected to the corporate debtor HCO Denim Private Limited being treated as a MSME, and these objections were noted in the meetings of the Committee of Creditors. It is also the case of the appellant Central Bank of India that the asset value of the corporate debtor such and such was more than the norms prescribed to qualify as MSME. The application for registration as an MSME was filed by the employee of the corporate debtor such and such, and on the same day, certificate dated 23rd October 2020 was issued. It is the contention of the appellant Central Bank of India that the certification has been wrongly procured and is contrary to law. We are conscious of the fact that we are hearing an appeal in terms of section 62 of the IBC and within its limited confines. We cannot go into the question of validity of the registration certificate dated 23rd October 2020. So within the confines of IBC, you can't do it. At the same time, the certificate having been placed on record, section 29A read with section 240A of the IBC would come into play and would affect the interests of the secured creditors, including the appellant Central Bank of India. Keeping in view the peculiar facts of the present case, we would permit the appellant Central Bank of India to file a writ petition before the Jurisdictional High Court challenging the issuance of the MSME registration certificate dated such and such. And then says, my lord, if any such writ petition is filed, it should be disposed of. Two things. First of all, it says, my lord, in the course of a regular appeal under section, well, and my lord, it is also important, paragraph 8, but it says that in the meantime, the proceedings before the adjudicating authority under the corporate insolvency resolution process shall remain stayed. Now, my lord, two things are important. One is, my lord, the court accepts, the Supreme Court accepts that, my lord, Supreme Court was hearing an appeal under section 62. Now, my lord, Supreme Court, my lord, of course, my lord, entertains special leave petitions under the provision of 136, but so far as statutory appeal is concerned, against an order of the NCLT, statutory appeal lies under section 61 before the NCLAT. Against an order of NCLAT, a statutory appeal under 62 lies before the Supreme Court. And the Supreme Court says, while dealing with a statutory appeal under 62, we cannot go into the questions. So therefore gives liberty to file, my lord, writ petition challenging the grant of MSME registration, my lord, to Central Bank of India, which was the petitioner before the court. And my lord, now, my lord, if your lordship will please see the NCLAT judgment also, which is, my lord, more expressive on the subject. My lord, this is the NCLAT, my lord, principal bench. No, this is a bench comprised of Justice Ashok Bhushan, Varun Mitra, and a 3-member bench. Well, please see paragraph 24 at page 16. May I just read this one paragraph?
Yes.
May I just read this one paragraph? The MSME Act as it stands clearly does not provide any supervisory role on the adjudicating authority to revise, modify, revoke or interfere with MSME registration at its level. Clearly, the notification framed thereunder also does not bestow upon the adjudicating authority with any such authority to hold an MSME registration to be null and void on its own. Even if adjudicating authority was so much convinced or persuaded to believe that there were errors in the calculation of the WDV in the grant of MSME status, to our minds, before embarking on any exercise of unilaterally undertaking calculation of the WDV at its own level, the adjudicating authority ought to have asked itself the question as to whether the Parliament, while framing the MSME Act, intended to bestow any such authority on it. In the exercise of summary jurisdiction by the adjudicating authority under IBC, the adjudicating authority is not expected to go into the details of accounts and examination of certificates issued by the competent authority under MSME Act and notification issued thereunder. The MSME registration can only be revoked by the competent authority, and the adjudicating authority cannot arrogate this jurisdiction upon itself to modify, revise, revoke, or interfere in any manner with the MSME registration granted by the competent authority. We are of the considered opinion that the MSME status of the corporate data as granted by the competent authority continues to subsist and could not have been disregarded by the adjudicator. And the adjudicating authority here is the NCLT.
And this order of NCLT was not taken higher up.
No, NCLT. This is the order of
NCLT.
Supreme Court gechilo. Oh, I am told, my lord, that there was a civil appeal preferred against this and it's been dismissed.
It was dismissed on merits by the Supreme Court.
My lord, civil appeal was not entertained. I am instructed, my lord. I do not have the copy.
Kindly satisfy yourself.
Yes, my lord. I will get the copy of the order. My lord, my learned junior says so. I have no reason to disbelieve it, but I'll check it up for myself.
There are other Supreme Court judges.
You don't have to multiply decisions. Now, my lord, to show your lordship as to, my lord, how the whole, my lord, situation started. My lord, as your lordship has been told by Mr. Banerjee, my lord, here the company, which is, my lord, Jagadamba Industries, was, my lord, declared to be insolvent in the sense that, my lord, CIRP was commenced against it on the 22nd of August 2023. My lord, this is a very important date. My lord, 22nd of August 2023, my lord, CIRP commenced. Now, my lord, here, my lord, when the resolution professional ultimately, my lord, put forward the...
How does on which date does CIRP commence?
22nd August 2020. My lord, when the petition is admitted on the same date.
When the petition is admitted.
My lord, when the petition is admitted on the same date, a resolution professional is, my lord, appointed. And, my lord, on the same date, by operation of law, my lord, the board of directors of the company is suspended, the resolution professional takes over.
Sir, sorry. This is the judgment in which the Supreme Court passes this order.
Yes.
Now, my lord, here, my lord, when the matter is put up, my lord, before the committee of creditors, the committee of creditors proceeds to sanction, my lord, the resolution plan of the third respondent. At that point of time, my lord, I make a complaint before the resolution professional that he could not have put up his plan because, my lord, he was a related party. My lord, that was my complaint. Now, my lord, to this, I should start with showing your lordship, my lord, what is, my lord, the response.
No,
lord, if
when did you raise this grievance, this complaint?
The complaint was, my lord, made. I show your lordship that exactly the date of the complaint. Complaint kothay, sir?
This will obviously not conclude, Mr. Shah. It will be of help if your juniors get us a short list of dates also.
But I have prepared one for you.
Let me rely on my list of dates. I have the entire dates, my lord, jotted down. But I will be happier if, my lord,
my lord, yes, it will be rising in 5 minutes because of the 3:30 rising today.
Lord, may I hand up, Lord, the list of dates?
He wants to rely on his list of dates.
No, these are unbiased dates. May I, Lord, I am appearing for the RP. May I just have 2 minutes, my lord?
My lord, my learned friend, my lord, has made it a habit of my lord ultimately taking over my arguments,
No, no.
hijacking my arguments.
Same name,
Same name, namesakes.
I am the lesser of the namesakes. That there is actually some urgency because
We'll hear it again tomorrow. Now that we have taken this up, this will be the first matter. বুঝেছো?
Yeah.
Because this will be the first matter.
আমার কি আছে?
এই তো, এই যে residuary appeal group 9 যেরম আছে, সেখানে যেরম আছে এটা এক নম্বর থাকে। Come back tomorrow, Mr.
Well, just one thing. Oh, my lord, I'm sorry, my lord. Your lordship wanted me to, my lord, tell your lordship as to whether, my lord, this was carried in appeal, that, my lord, the judgment of the NCLT. Well, it is, my lord, this judgment, my lord, that is, my lord, has resulted in the order in the central bank matter. Oh, I should have, my lord, noticed that. My lord, this, my lord, has been carried in appeal, and this is, my lord, the observation of the Supreme Court in that appeal.
And I get the other judgments in which credit for not it.
My lord, subject to correction, that I believe is still pending in the Supreme Court.
Correct. Correct.
It's not disposed.
It's before Bombay High Court.
Let us,
Very well.
Yes.
Come back tomorrow. We take up original side. Kalke to same to 3 p.m. or after exhaustion of appellate side, whichever is earlier.
Well, I'll have a list of dates ready for you.
देखो, Mr. Jishnu Shah, learned senior counsel representing the appellants, begins his argument but does not conclude. Paragraph. List the matter once again. Kalke date diye dao as the number one item, in the original side list. এইখানে নোট করছি মনে রেখো।
I'm assisting. Never ask for a list of things. You are a stop.
ना 3 PM ना
3 PM का फिर एग्जिट साइड खत्म होने के बाद
একবার দেখে বলতো এই সঞ্জনা আমি দেখে তোমাকে বললাম না আমাকে 98 318 hello 080 44 define